very well. Okay. Okay. Bill, are you hearing? I got a message from Philip Simpson that he was not hearing anything.
I'm not hearing through my headphones. I'll switch to a computer for now. Can you hear me?
Yes.
Thank you.
Measure. Worse.
Good morning. We're here in the matter of 22-00093 UT, an application for approval of El Paso Electric Company's 2022 Renewable Energy Act plan. And I would ask council to and pro se parties to enter their appearances for the record.
Good morning, Madam Hearing Examiner Carrie Olson from Montgomery and Andrews on behalf of EPE El Paso Electric Company. And then I just wanted to let you know that Mr. Wexler is going to be joining me in just a few minutes. He's wrapping up another hearing. So I'm entering his appearance as well. Jeffrey Wexler, Montgomery and Andrews on behalf of El Paso Electric Company.
Thank you, Ms. Olson.
Okay, I'm Mary Lee Souls. I'm a pro se party in this case.
Thank you, Ms. Souls.
And I'm Alan Downs, also a pro se party in this case.
Thank you, Mr. Downs.
Good morning, Madam Hearing Examiner. This is Anastasia Stevens representing the City of Las Cruces, and I'm looking to track down my other witnesses. Thank you.
Excuse me, am I to introduce my witnesses as also or not?
No, that is
Oh.
not necessary at this time. Thank you.
Thank you very much.
Madam Hearing Examiner, I know the instructions were to have everybody check in at the start of the hearing, and right now on the screen I only see Mr. Provencio. Should I try to, Jose Provencio, should I try to reach my other witnesses, or does that not matter at this point? I'll text them on the phone.
I think the purpose was to ensure availability and also to ensure that they were able to use the Zoom link appropriately. So if your witnesses are available and have checked on their use of Zoom, I don't think it's necessary at this time.
Thank you. That way I can set my phone down.
Okay. Go ahead.
Madam Hearing Examiner, if I may. Brad Borman appearing on behalf of Utility Division staff. I am joined by co-counsel Gloria Regensburg today.
Good morning.
Good morning, Madam Hearing Examiner. My name is Victor Martinez. I'm a witness on behalf of El Paso Electric.
Mr. Martinez. Any other counsel entering their appearance this morning?
Good morning, Madam Hearing Examiner. Gideon Elliott on behalf of the Attorney General's office.
Mr. Elliott, thank you.
Madam Hearing Examiner, Keith Herman on behalf of Doña Ana County. And as a preliminary.
This audio is no good.
I'm sorry, I couldn't hear that. Was that a problem with your audio, Mr. Herman?
How about now?
I did hear that.
Okay. I was just saying that throughout the hearing, I may need to excuse myself, and I understand if I'm absent, I will waive any cross-examination that may occur during my absence, and I will be bound by any determinations made by the hearing examiner in my absence.
Thank you, Mr. Herman. Yes, those would be the conditions.
Madam Hearing Examiner, I apologize, but I also will have that situation arise as well, particularly at 11 o'clock this morning.
All right, thank you, Mr. Elliott. I would ask, we have one of our commissioners here today. I just admitted him from the waiting room. Commissioner James Ellison, if you'd like to introduce yourself, Mr. Ellison.
Hi, everyone. I'm Jim Ellison. I won't be able to sit in for the entire proceedings today, but I'm very interested in this case and look forward to hearing what's said. Thank you.
Thank you, Commissioner. All right. Any other appearances of counsel or pro se parties for the record? Okay. We did have one individual who signed up to make public comment today. I do not see that individual, Martin Lanham, is in the room yet. Mr. Lanham, if I'm mistaken about that, can you enter your appearance as well? Okay. Well, we'll wait a few minutes and then check back on Mr. Lanham. In the meantime, I think the first order of business, and I appreciate all of the witnesses who have appeared this morning. I would say that at this point, any party who is not either going to participate in the examination of witnesses or our first witness today, which would be a witness of EPE. I would request that you watch the hearing on YouTube in order to improve the quality of the Zoom meeting for those who are actively participating at any particular time. And then the next item of business will be to review the exhibits. And then before we actually start testimony, finally, we will discuss again potential dates for Ms. LaRoque's testimony. All right. So I'm looking, Ms. Olson, at your exhibit list at this point in time. Have all the parties had an opportunity to review the exhibit list provided by El Paso Electric?
I am just reviewing it now, Madam Hearing Examiner.
Well, pursuant to our discussion at the pre-hearing, our first order of business was going to be to determine whether or not there were going to be objections to any of the proffered exhibits. So we'll start now. Ms. Olson, exhibits 1 through 19 are the exhibits that you intend to offer today or during the hearing today and tomorrow?
Madam Hearing Examiner, that's correct. We'll certainly be offering EPE exhibits 1 through 9, which are the testimonies. The remaining exhibits are intended for cross-examination and will be admitted or moved for admission during cross-examination as appropriate.
Thank you. Are there any objections to exhibits 1 through 9, which would be the direct and rebuttal testimonies of EPE's witnesses? Okay. Hearing none, I am going to just go ahead and admit EPE exhibits 1 through 9 at this point in time. Mr. Borman,
Yes.
can you identify the exhibits that will be offered by staff, or would that be Ms. Regensburg? Sorry.
I can do it. The exhibits that we will have would be, we have 2 exhibits. Exhibit 1 would be the direct testimony of Mark Tupler, and exhibit 2 would be the direct testimony of Bamadou Utara.
Okay. Are there any objections to staff exhibits 1 and 2? Okay, hearing none, staff exhibits 1 and 2 will be admitted. City of Las Cruces, why don't you go ahead?
Thank you, Madam Hearing Examiner. I have a little problem. I should have brought this up at the pre-hearing conference last week, but I totally forgot until I was looking at his testimony again. Mr. Provencio's testimony, which is City Exhibit number 3.
Yes.
I so apologize. This totally slipped my mind. It ended up being filed a minute or 2 late at the commission on the 9th of January. And I filed a motion. You said you would grant it. I refiled it with the date and with the correct footers, footers on the bait stamps footer thing. So right now, and then I forgot that when I uploaded his testimony as CLC Exhibit 3. So at this point, I'm afraid that, first of all, I not necessarily the absolutely perfect document. The content is identical. It's all in the footers and the date on the first page. And secondly, I need your permission to admit it, to accept it in the first place. So
your motion with respect to Mr. Provencio's testimony is granted.
thank
So
you.
it will be considered.
Now, now shall I replace, since he won't be going on for a while, shall I replace or add to the Dropbox the one that does say January 10th and has the correct footers, or is that not worth the trouble?
Why don't we not do that at this point?
Okay.
Okay.
And then with that, city also would like to admit at this point, CLC Exhibit 1, which is the direct testimony of Lisa LaRock, and CLC Exhibit number 2, the direct testimony of Edwin Reyes Jr. The rest of our exhibits, which are 4 through 15 of them, are for cross-examination purposes. And several of those are past orders or commission rules that I wouldn't necessarily intend to enter into evidence anyway, just essentially use them as a demonstrative for talking with the witness. So just want to let you know.
Okay, thank you. All right, yes, Ms. Olson.
I just want to make sure we're not waiving any rights. So EPE does have objections to one of the city's exhibits, not the testimonies, and I'm happy to reserve those objections until such time as Ms. Stevens plans to seek it or plans to use it. But I just want to make sure, since we were asked to come prepared first thing this morning with any objections, that I'm not inadvertently waiving that.
No, you're not. So at this point in time, I believe the city of Las Cruces is only offering the direct testimonies of its experts, Ms. LaRoque, Mr. Reyes, and Mr. Provencio. Is that right, Ms. Stevens?
Yes, ma'am.
Okay. All right. Are there any objections to those 3 exhibits?
No.
Madam Hearing Examiner,
Yeah.
I don't have an objection. I just wanted to note a point of order that generally the exhibits are admitted at direct testimony upon a witness verifying that those statements are true and correct, and upon direct examination.
That I appreciate that, Mr. Herman, and we will ensure that we do have that affirmation at the commencement of each witness's testimony.
Thank you.
All right. All right. Any other direct testimony that will be offered this morning?
Yes, Madam
Ms.
Hearing
Souls?
Examiner.
Go ahead, Mr. Elliott.
The Attorney General's direct testimony, OAG 1. The direct testimony of Debbie Glick.
All right, thank you. And subject, of course, to affirmation, is there any objection to OAG Exhibit 1? Okay, hearing none. Thank you, Mr. Elliott. That will be admitted, and of course, subject to affirmation. Ms. Souls?
Yes, ma'am. It would be Souls Exhibit 1 through Exhibit 4 is the direct testimony of myself, of Corey Aspel, of Philip Simpson, and my rebuttal testimony, the rebuttal testimony of Mary Lee Souls. And Madam Hearing Examiner, at this point, am I offering Souls Exhibit 5, which is El Paso Electric's amended 2021 Integrated Resource Plan?
Is your intent to use that during cross-examination, Ms. Souls?
Yes, ma'am.
Okay. Then we will hold off on offering that exhibit until such time as you utilize it in cross-examination.
Very well. I do have another question, and that's regarding the supplemental testimonies in response to bench requests. that were
Yes.
provided this morning, will they be admitted as well?
I will ask about whether or not they're going to be offered by EPE and by staff once we've completed this process.
Very well, thank you.
At this point, is there any objection to the exhibits 1 through 4 offered by Ms. Souls? Well, hearing none, again, those will be admitted subject to affirmation during the course of presentation of the witnesses. Finally, Ms. Olson, do you plan to offer the responses to bench requests? And same. Go ahead, Ms. Olson.
In response to your question, I understood from the bench request order that the commission intended to introduce them as commission exhibits. But I'm happy to do whatever yourself or the commission directs. They are not currently marked as EPE exhibits. And I don't want to throw off the numbering of the marked exhibits, so we could mark them as continuation after the disclosed exhibits, recognizing there could be a gap in numbering if we don't end up introducing all those exhibits. But however, whatever makes the most sense to you, we're happy to do.
All right. Well, I think at this point, then we'll wait on those exhibits, and we'll discuss them at the time that those witnesses are examined. So, thank you. All right. Does that answer your question, Ms. Souls, with respect to the responses to bench requests?
Yes, ma'am, I believe it does.
Madam Hearing Examiner, I have a question about the bench request responses. I mean, obviously they were seen by us about an hour ago. Caused me to kind of have to rejuggle my cross-examination, but also I have a potential additional exhibit that I would, if we were to if we're expected to examine the witnesses, that's going to be admitted into the record. There is one potential additional cross-examination exhibit that I have identified in that short time that I might need to use. It's a document, it's an EPE report on file with the commission.
Well, we can wait on that until such time as that witness is testifying. All right. I'm checking to see, I don't see that Mr. Lanham has entered the room for purposes of his public comment. Let me double check to make sure I don't have any other communication with respect to that.
And Madam Hearing Examiner, while you're checking on that, I understand that the EPEIT has asked for admission into the hearing room.
I believe that I did admit them.
Okay. Thank you.
Okay. I don't see any other communication from Mr. Lanham, so I think at this point, I'd like to address the issue of potential dates for testimony of Ms. LaRoque. You know, I'm not sure why I brought up dates in March during the pre-hearing. I guess I was thinking about the 19-00099 case when I did that, because I believe that we should clearly have the testimony of Ms. LaRoque much more, much closer in time to this hearing. So I had suggested some dates in the second and third weeks of February. So if we could try to nail that down, I would appreciate it. I think that if I'm correct, the 16th was a date that everyone would be available. Is that correct? And I believe our court reporter, Ms. Gonzalez, is available on the February 16th.
Which day of the week is that, please?
It is Thursday.
Thank you.
So not hearing any, that there is anyone who is not available on the 16th. I think we will set Ms. LaRoque's testimony for 10 a.m. on February 16th.
Thank you very much, Madam Hearing Examiner. The City of Las Cruces truly appreciates that.
Okay. All right, and we'll send out a notification on that and then a Zoom link to everyone. Thank you. So I believe at this point, we should be prepared to proceed with EPE's first witness, Ms. Olson.
Thank you, Madam Hearing Examiner. EPE would like to call Mr. George Novella as its first witness.
Ms. Gonzalez, can you swear in Mr. Novella?
Raise your right hand, sir. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
All right, go ahead, Ms. Olson.
Good morning, Mr. Novella. How are you this morning?
Very well. How about yourself?
Pretty good. Trying to get organized here. Okay, will you please state your full name for the record and spell it?
Yes, George Novella, George, and Novella is Nov as in Victor, ELA.
Mr. Novella, what is your current profession?
I'm currently a director with El Paso Electric.
Do you have before you what's previously been marked as EPE Exhibit 1?
Yes.
And do you recognize that document?
Yes, I do.
And is this your pre-filed direct testimony?
Yes, it is.
Was that direct testimony drafted by you or under your direct supervision?
It was.
And are the exhibits identified on the table of contents part of your direct testimony?
It is.
Do you have any corrections to your direct testimony?
I do. I have 2 corrections to my direct testimony.
Okay.
Would you like me to go by the bait numbering?
Sure, if you have that
Okay.
available.
On page 42 of 821, on line 8, it reads 40 WM. It should be 40 MW for megawatts.
Okay.
The second correction is on page 46 of 821, line 3. Instead of 2019 to -2020, it should just read 2022.
I'm sorry, what page was that, Mr. Novella?
46 of 821.
Thank you.
You're welcome.
And those corrections are pre-marked on the exhibit that we provided. Mr. Novella, is the direct testimony with those corrections true and accurate to the best of your knowledge and belief?
It is.
And if you were asked these same questions today, would you give the same answers under oath?
I would.
And I understand the exhibits already been offered subject to that affirmation. So we'll move on to EP Exhibit 2. Do you have that before you?
I do.
And do you recognize that as your rebuttal testimony?
Yes.
And was the rebuttal testimony drafted by you or under your direct supervision?
It was.
And do you have any corrections to your rebuttal testimony?
I do. I have 2 corrections on page 41 of my rebuttal testimony. Line 2, there's a date that says October 5th, 2015. That date should read October 28th.
And the next correction?
The next correction is actually on the next line, line 3. There's a rule being referenced, 19.9, and instead of 19, it should read 17. So 17.9.
Thank you, Mr. Novella. With those corrections, is the rebuttal testimony that you prepared true and accurate to the best of your knowledge and belief?
It is.
And if you were asked these same questions today under oath, would your answers be the same?
They would.
Madam Hearing Examiner, at this time, we tender Mr. Novella for cross-examination.
Thank you very much, Ms. Olson. I believe that the Office of the Attorney General would be first in cross-examination. Mr. Elliott?
We have no questions at this time. Thank you.
Madam Hearing Examiner.
Yes, Ms. Olson.
Mr. Novella did provide supplemental testimony. Will that be introduced here?
Well, we're going to go through the cross-examination first, Ms. Souls. Thank you.
And I ask because I anticipate I may have cross-examination questions based on that, and perhaps the other parties will also.
Madam Hearing Examiner, this is Anastasia Stevens.
Yes,
As
Ms. Stevens.
Yeah, as I mentioned earlier this morning, upon receiving the response to the bench request, I've rather rapidly reshuffled my cross-examination on the expectation that that bench request response was going to be admitted. So I would definitely like some clarification as to what the corpus of Mr. Novella's testimony is in this case, because I didn't like having to do it, but I did, and I don't want to. I'm not prepared to go and undo it at this instantaneously.
Okay. So Ms. Olson, why don't we go ahead and mark Mr. Novella's response to the bench request as Commission Exhibit 1. And if you could just have Mr. Novella affirm that testimony, we'll admit it as Commission 1.
Okay, I'm happy to do that. Mr. Novella, do you have a copy of your supplemental testimony that was filed this morning?
I do.
Okay. And was this supplemental testimony drafted by you or under your direct supervision?
It was.
And do you have any corrections to your supplemental testimony?
I do not.
Is the supplemental testimony that you prepared true and accurate to the best of your knowledge and belief?
It is.
And if you were asked these same questions today, would you give the same answers under oath?
I would.
Okay. Any objection to Commission Exhibit 1? Okay, hearing none, Commission Exhibit 1 is admitted. I see that Mr. Lanham has now actually entered the hearing. Mr. Lanham, you are currently on mute. Can you unmute, and do you have video available? Mr. Lanham?
Yes, can you hear me?
Yes, thank you. Do you have video available?
Yes, I can see you.
All right, thank you, Mr. Lanham. At this point in time, with EPE's indulgence, I would ask to take a break in Mr. Novella's testimony to allow Mr. Lanham an opportunity to make his public comment.
No problem.
Okay. Go ahead, Mr. Lanham.
I do particularly appreciate this very much, as I had a medical emergency befall me when I was scheduled to testify at 10 a.m. So I do appreciate EPE's indulgence and the PRC's indulgence on this. My comments are very, very simple. I am a solar system owner. My system is sufficient enough to carry my entire property, plus some reserves. It consists of a little over 11 kW. And since my system went live on May the 25th of 2021, I think it was, I have not, in fact, purchased sufficient amount of electricity from EPE to exceed my credits on a monthly basis. In other words, my bill has been zero every month. My problem is that this particular rate plan that EPE wants to institute targets solar system, people with solar systems such as myself. Correct me if I'm wrong, but I believe they're requesting, is it a 24.5% increase in the rate of the power that we purchase back to use during the off hours. Having worked in the electrical generation industry for 58 years on a worldwide basis, this is an intent to really squeeze out any solar system owners in the future and put a hobble on those who currently have solar systems. As we all know, utilities, and especially electric utilities, are a monopoly, whether we like it or not. I mean, that's the way it is, and that's the way it will probably always be. But to take on one classification of ratepayer, which in this case is the solar people with solar, is really against any good type community relations that EPE hopes to maintain now or in the future. We're not here to guarantee EPE a percentage, a margin of profit based upon anything that they do. If their gas costs go up, that's an operating expense that should not necessarily be passed on to the consumer. In this case, it makes no difference what your ratepayer level is. But to do that, to increase the percentage that EPE wants, without a reciprocal increase in the cost per kilowatt hour that EPE wishes to or wants to purchase the off-peak availability from solar people such as myself. And like I say, I'm not in the business. I just happen to have an extra giggle wiggle or two available every now and then. is really countermand to what the intent of the entire solar program is, even all the way up through the federal level. So I would ask that the board really give this a very serious consideration. I have not seen anything in paperwork or filings that EPE has made that justifies a 24.5% increase. All right. I'm not saying they can't justify it. Please don't misunderstand me. I'm saying that to date, I have seen nothing. And I would request that those filing be made by EPA for the board to take serious consideration as to if the increase that they request is justifiable. And I would like to resend a copy of those papers also for review. And that's all I have to say. I appreciate your indulgence.
Well, thank you, Mr. Lanham. If you do have any written submissions, they can be submitted as written comments for purposes of the record in this matter through email to PRC records.nm.prc.gov.
Along with the rate case number.
Yes, thank you. Yes, that's correct. Yes, that is correct. All right.
Just a quick question. Do you have any ballpark idea as to when a decision would be reached on the rate case?
There's going to be a continuation of the hearing on February 16th.
Okay.
So I don't anticipate that we would have a decision in this matter for a couple of months anyway.
Okay. Is it possible that on the hearing of this February the 16th, while I don't wish to testify at that time, that I might be able to at least listen in?
You are welcome to listen into any of the testimony in this matter. It's all being live streamed on YouTube. So if you go to the PRC website, you would be able to access the YouTube stream for today and tomorrow, as well as February 16th.
Okay, thank you very, very much.
You're welcome. Thank you for your comment, Mr. Lanham. We appreciate it.
Thank you, and I hope everyone is safe and has a good week.
Thank you.
Bye-bye.
All right. We'll be returning at this point to Mr. Novella. I would ask if Commissioner Ellison has any questions for Mr. Novella before we proceed to the next party. Commissioner, you're on mute. Do you have any questions for Mr. Novella? Okay. Hearing none, I would ask Mr. Lanham at this time, we're trying to reduce the number of individuals in this meeting.
Yes.
Certainly appreciate your attendance through the YouTube stream if that's available to you.
Okay, fine. Yeah, I will sign off then from this stream.
It appears that the hearing examiner's video stream is frozen.
Oh,
And she's down for the count. She'll probably pop up in a minute.
mhm.
All right, everyone. I do not know what happened, but I was temporarily disconnected from the meeting. At this point, let's go ahead and continue with Mr. Novella's testimony. Since Commissioner Ellison didn't indicate that he had any questions, Mr. Elliott also indicated that he didn't have any questions. Next would be the City of Las Cruces, Ms. Stevens.
Thank you, Madam Hearing Examiner. Good morning, Mr. Novella. How are you?
Good. How about yourself?
Good. It's been a while. You've had a promotion since the last time we saw you, right?
I'm not sure. That was in early 2021. I'm not sure.
Maybe about that time. It was the rate case hearing, wasn't it?
I'm not sure when the
Yeah.
last time we saw each other was, but it probably was around that time.
You haven't testified in previous Renewable Energy Act plans, have you?
No, this is my first RPS case.
And did you you didn't testify in case number 19348, the Buena Vista and Hecate 1 PPAs, did you?
No, I don't believe so.
But you did testify in the Newman Unit 6 CCN case, 19349 UT?
That's correct.
In prior cases, your testimony has been mostly about load forecasting and econometric kind of issues. Is that right?
Partially.
In assuming you're, I'm so tempted to say this, but it would be mean. Now that you're Jim Schiestel, should we have a little levity here? In preparing for your new, I gotta smile at you there. How did you, given that you haven't testified in the previous REA cases, did you review the actual PPAs for Buena Vista and Hecate, or is that part of your general job responsibilities anyway?
Like any other case that's new, I'll go back and read a previous testimony filed in the most recent case. Try to.
And did you help? Did you help negotiate?
I'm sorry. He's still speaking and I can't hear everything he's saying.
Sorry.
Wait, so like any other case, I'll go back and read previous testimony filed in the most recent case to try to
get a general understanding of past issues and history.
And did you read the orders in the past cases?
I read the stipulation from the previous case.
But not the commission orders?
I may have. There's a lot of material, and this case specifically has a lot of material and a lot of history that it brings with it. So I may have looked at it. I can't recall.
And for this case, did you look at the Renewable Energy Act?
Yes.
And the Renewable Energy Rule?
Yes.
Did you look at other commission rules?
Yes.
Would those include Rule 551 on long-term purchase power agreements?
Yes.
Would you please turn to CLC exhibit number 5? I hope you have access to everything.
Can you see the exhibit again, please?
Number 5, CLC exhibit 5.
Is it the order adopting the recommended decision with additional instructions?
Correct.
I'm there.
And you remember that in that case, the commission disapproved EPE's request for CCN for Newman Unit 6, a gas generating unit?
Can you point me to the language that you're referring to in this
No,
document?
just generally, you remember that the outcome of that case was denial of a CCN for Newman 6?
I believe so, yes.
Would you turn to page 10 of 14 of that document, please? The bottom of the page, paragraph 33. Would you read that language out loud? That sentence.
Okay, page 10, what?
Page 10, paragraph 33 at the bottom of page 10 of 14.
The commission further finds that EPE should be ordered to provide an next application for approval of any resource acquisition, whether by CCN or long-term purchase power agreement, a comprehensive plan showing how EPE will comply with the renewable energy and zero carbon energy requirements of New Mexico law.
And would you agree that this is EPE's next application for approval of a new resource acquisition since that order was issued?
I'm not sure if they have had a previous filing for any other acquisitions or for any other generation, but I believe this is the next one since that Newman case.
Can you point to where in the company's application and testimonies is that comprehensive plan showing how EPE will comply with the renewable energy and zero carbon energy requirements of New Mexico law?
Yeah, well, I think that's this entire filing, and more specifically, a lot of the data that EP witness Martinez shows, where he shows by year and going out to the end of the REA in year 2045, how EP will comply and be in compliance going forward.
Do you believe that Mr. Martinez's testimony takes us out to 2045?
I'm not sure how far his tables go out, but it definitely goes out into the outer years, showing how EP will comply at least through the 40% requirement in 2025.
Is 2025 the outer year?
From current year, I see it several years forward, yes. Now, I can't recall exactly all of his documents and how far out he goes.
Would you like to turn to Mr. Martinez's? He's done this several times, but we can go to his, let's see what's the easiest one to go to. We can go to EPE Exhibit 4, which is Mr. Martinez's rebuttal.
Okay.
And I'm on page 13 of 34 in that document. And you see on the top of that document, there's a table labeled table VM-1R. How far out are you with me?
Okay, and which page is this table on? 13 of 30?
Page 13 of 34.
Okay, I'm there.
And do you see that that goes out to 2026?
Yes, this table goes out to 2026.
Do you believe that EPE has provided any information in this entire filing that goes beyond Mr. Martinez's table that goes to 2026?
I'm not entirely sure if Mr. Martinez provides any exhibits or other material that go beyond this year.
You haven't provided information that goes beyond 2026, have you?
No.
And if you turn to, let's close that one since I've lost your face. Sorry about that. I have to work on my screens here. If you go to your own rebuttal testimony at page 11 of 43.
Okay, I'm there.
I'm not, give me 1 second. Where is it? I'm taking you to the wrong page. It is page 11 of 43. I was looking at the number in the bottom of the page. I'm looking at the answer on the bottom, starting on line 16. And your testimony is EPE appropriately filed for Carney approval as part of its 2022 plan as a, quote, necessary component of EPE's plan to make reasonable and consistent progress towards the REA renewable and clean energy goals, unquote. Again, where is the plan and which goals are you talking about? Let's start with which goals you're talking about there.
Sure. Well, with regards to the general REA, and when you're looking at Rule 572, there's several line items with regards to items or criteria that you need when filing under the REA, and EPE has addressed all of these requirements properly in this filing.
That's not the question. I'm asking not the necessary component of EPE's plan, not necessary component of a filing under Rule 572. You have two concepts in here, the way I read this, Mr. Novella, I see two concepts in here. First is the reasonable and consistent progress towards the REA renewable and clean energy goals, right? See that phrase?
Can you restate your question? I'm sorry, I've kind of lost me.
So let's break this into two concepts. First of all, reasonable and consistent progress towards the REA renewable and clean energy goals. That's a concept that, is that a concept that comes from the Renewable Energy Act?
So your question, can you restate your question again? I apologize.
Does your assertion here about making reasonable and consistent progress towards the REA renewable and clean energy goals, is that something required by statute?
Let me go to that section of my direct testimony.
Madam Hearing Examiner, I'm going to object to the extent this is asking for a legal conclusion. I understand Ms. Stevens is asking, is the Renewable Energy Act, renewable and clean energy goals under the Renewable Energy Act?
Ms. Stevens, do you have a response?
I think that I think I'm asking him not whether statute says, but whether his testimony is addressed at meeting a statutory requirement.
Okay. Why don't you rephrase your question to clarify that, Ms. Stevens?
Okay, I will do that. Thank you. So,
thank you.
When you say here that you have EPE has a plan to make reasonable and consistent progress towards the REA renewable and clean energy goals, is that are you responding to a requirement of the statute or the rule there?
Yes. If you go to my direct testimony, page 32 of 821, line 3.
I'm not with you because I'm lost in that gigantic thing. Would you give me that number again, please?
Yes, of course. Page 32 of 821.
Okay, now I'm with you.
And the paragraph at the top of the page starts with Mr. Martinez.
Mm-hmm.
If we go down to line 4, I described that we are required to comply with the RPS selected pursuant to Rule 572.10 to demonstrate reasonable and consistent progress towards meeting the RPS to be effective the following end of the plan year. Does that answer your question?
Well, actually, that leads to my follow-up question. Thank you, Mr. Novella. Is in your interpretation, are you trying to present in this case a presentation of the needs? Your direct testimony says the RPS to be effective following the end of the plan year. We're talking about plan year 2023, right? In this case?
That's correct.
And so the year following 2023 is 2024?
The year following 2023 is 2024.
Okay. And what is the RPS to be effective in 2024? Do you know that?
Can you restate your question? I'm sorry, you lost me at the 2023 to
What is the RPS? What is the required RPS for 2024?
Oh, 20%.
Now, when we flip back to your rebuttal testimony, are you talking about meeting the RPS of 20% in 2024? Are you talking about a longer term perspective?
And can you point me to where you're?
Oh, I hope I'm still on the same page where we were before. Give me one moment here. Yeah, okay, we're back to page 11 of 43 of your rebuttal.
Okay, I'm there.
So in this testimony here, are you addressing the same 2024 next plan year REA goals or longer term ones?
On the queue starting on page 11, line 12?
Yes. Yeah.
Let me give this question a look.
Please.
Okay, what is your question? I read that queue.
Okay, so the question was, unless Madam Hearing Examiner, you want me to ask the court reporter to read back. Question in substance was, is this testimony directed at meeting the 2024 goal or a longer term perspective?
It's in reference to properly filing for the procurement of a resource within this filing for future need, and that we properly filed for such a resource.
So is that a longer term perspective? Is that what you're saying?
Well, with regards to Carne and with how it helps us fulfill RPS requirements, it definitely helps do that. And more specifically, it really helps us get us to that 40% RPS requirement in 2025, which is the year that I believe that it's expected to go on live.
And when you say, going back to this exact testimony here on your rebuttal testimony, when you say it's a necessary component, what do you mean by necessary?
Sure. If you look at the testimony of EP Witness Martinez, I think he clearly shows that in order for us, EPE, to get to these mandated goals, Carne or the Carne project will be an important needed facility in order for us to hit that 40% threshold.
And is it your opinion that a smaller project than Carne would be capable of meeting the 40% goal?
Can you define what you mean by small, however you describe that project?
Well, I don't want to drag you through all of Mr. Martinez's testimony, particularly since it keeps changing those tables. But if we go back to, since I might still have it open, if we go back to his No, that's not the right picture. We go to, oh dear. If we go to that table that we were looking at with the 2026, which I think was Mr.
I'm sorry, which exhibit?
It's EPE Exhibit 4. Mr. Martinez's rebuttal testimony, Exhibit VM14 on page 13 of 34.
I'm sorry, exhibit BM14?
Yeah. No, EPE Exhibit 4, table VM1R on page 13 of 34 of Mr. Martinez's rebuttal.
Okay, I'm there.
Okay. Now, are looking at, and I'm not asking you to attest to Mr. Martinez's numbers. I'm just asking you whether whether a project the size of Carne is needed to hit the 2025, given that Mr. Martinez's numbers say that with Carne in for part of a year in 2025, you'll hit 52.2%, not 40. So to find smaller would be closer to 40, I guess, in terms of my question.
Oh, okay, I understand your question now. And I think it comes down to the fundamental part of the RPS that these are all minimums. So the 40% is a minimum. There's no maximum. So if you were to search in the rule, you'll see that these are minimum thresholds. And in fact, actually, utilities are incentivized to go beyond these percentages, these minimums. So seeing a percentage above 40 makes sense. And in fact, when you think about generation, and you mentioned CCNs earlier, and I like to think about generation as kind of lumpy. It's not a technical term, but generally you have injections of load or capacity. These facilities come in and they're not scalable, meaning they're not every year. You can't dial up or down to the perfect requirement. As you inject it, it may be lumpy. And in this case, you might have a percentage that's above the minimum. But as the years go by and as the EP has more sales, say, that percentage can come down. So I'm not surprised at all to see that type of percentage.
Well, I was going to ask these questions of Mr. Martinez, but I know that you do the loads, you used to at least do the loads and resources tables and things like that. When you talk about, I understand this lumpiness.
I just want to make a correction. I've never done or been in charge of the loads and resources table.
Oh, not the loads, just the forecasts that go are kind of, you do the demand and energy forecast part of that?
That's correct, ma'am.
You do the, yeah, they do the, so on this idea of lumpiness, which I understand, it's a kind of an old fashioned concept, I think nowadays. Sometimes people don't know that anymore. Do you know how much of EPE's total energy Carne would represent for New Mexico? This is dedicated to New Mexico, right?
There were two questions in there. Do you mind breaking them up, please?
Okay, yeah. So this Carne is dedicated to New Mexico as proposed, right?
Yes.
And do you know how much of New Mexico's total load in energy, not load, let's stick with energy. How much total energy Carne for a full year of Carne would represent?
No, I don't. I would suggest asking EP witness Martinez that question.
And do you know how much demand or peak capacity Carne would represent?
The Carne project has two facets, I believe. One is a 130 megawatt solar facility, and it's joined with the 65 megawatt energy storage facility. Now, with regards to the capacity it serves at peak or those types of detailed questions, I would save those for EP witness Martinez.
I just want to very quickly look at the bench request responses. Your bench request response, just mention Exhibit 1. And also page 10 of your direct testimony. And my question regarding, and I understand what you're saying about substantial compliance. That is the idea of making up past deficiencies with future recs. Is that right?
I'm sorry, Council, you mentioned two documents and didn't point.
Okay.
So where would you?
Initially, Exhibit 1, which is the supplemental testimony you filed today. Got that?
What page?
This is just generally, it's not, it's there, it's most of your, most of the testimony there. It's just a conceptual point. I think that you don't need to go to a specific line. Your position in that, in the company's position, your position in that supplemental testimony, that substantial compliance means that EPE will retroactively make up for past deficiencies on a one-for-one basis. Would that be a fair summation of what you say in response to the several questions you received?
Let me look at the document. Okay, can you restate your question?
So would it be fair to say that in a nutshell, your testimony in response to the bench request is that the phrase substantial compliance means that the company plans to retroactively make up for past deficiencies in meeting the RPS on a one-for-one basis with recs, excess recs generated in the future?
I would describe it as over time, over the next couple of years, EPE will make up for a cumulative deficiency.
I'm sorry, EPE will
make up for a cumulative deficiency that it has for its recs with future excess rec generation.
And where do you get the next several years from? Is there a requirement in a past order or a rule or a statute to do that?
The way I interpret it, at least past orders, is that EPE can use future recs, excess recs, more specifically. I'm not sure if there's a year or years going out, but these excess recs, as Mr. Martinez will show in his table, exactly year by year, when EPE will satisfy each previous year where it had a deficiency. And he also separates out overall cumulative deficiency. It has that nice breakdown on the table you were pointing to me earlier, that can help you guide you through that.
No, I'll ask I'll go to Mr. Martinez for the numbers. Thank you. So let's move on to because this is also touched on in your supplemental testimony. Is the company for the first time, it's actually more Mr. Martinez's supplemental testimony, but you lead into this. Is the company for the first time incorporating into its analysis of its RPS requirements the interpretation of the Renewable Energy Act provisions of DGs, distributed generation recs?
I'm sorry, the rural energy, I'm sorry, please repeat that.
The Rural Energy Act's requirements for distributed generation, or DG, capital D, capital G, RECs, RECs. Is it, well, now that I've explained it clear, is the company for the first time in the supplemental testimony attempting to address the DG REC issue as a potential limitation on the recs it can use?
Can you describe what you mean by DG rec issue?
Well, and let's go to page 26 of your direct testimony.
Of my direct?
Direct, yes. Because you testify about this.
Is it the Bates page or the document itself page?
Let me check. My notes say 26. I'll have to. I think it's probably the page number. Yeah. Yeah, here it is in the lower half of page 26, Bates 42.
Okay, I'm there.
And then specifically on the top of page 27, you stated in your direct testimony under section 62.16.5B1B of the REA, EPE is the owner of all RECs generated by these qualifying facilities. What was the basis of that testimony, Mr. Novella?
Sure. So again, this is my direct testimony, and since we filed our direct testimony, I believe there's been a rulemaking on some amendments with regards to Rule 572, and more specifically on how many and what type of RECs EP can register and retire. And at the time of me writing this direct testimony that you reference, there wasn't a finding or there wasn't a rulemaking that was completed yet with regards to that issue. And so at this point in time, EP's stance was that EP could register and retire all RECs from New Mexico customer-owned distributed generation systems.
So is it still your position that EPE is the owner of the RECs, all the RECs under the statute?
So again, as I said, there's been a rulemaking, and actually, like what staff said on this, staff witness Tupler, where he suggested that for this filing specifically, that the existing treatment of RECs be followed, since the amendment that I'm talking about exit for RECs is not active yet. But for the next filing, so for this year, going into the 2024 cost rider, if active with regards to that change that I'm describing, then EP will use that new treatment for how it registers and retires RECs.
I'm asking you about the testimony here on your testimony, EPE is the owner. That's still EPE's position.
Well, I thought I just answered it. So at that point in time, this was before the rulemaking. So that was EP's position when the direct testimony was drafted. And since then, these new items have come up with regards to this rulemaking being authorized on EP only being able to register and retire, I believe, excess net RECs is the terminology I would use. So those RECs that EP buys based on rate 16 in New Mexico.
Do you understand the difference between owning RECs and being able to apply them to RPS retirement?
I'm not sure I'm following your questions.
Okay, your testimony here says you are the owner of all the RECs. I'm asking you whether the company still believes that they're the owner of all the RECs, and then they just have a limitation on which ones they can use to retire to prove that compliance with the RPS requirements.
I'm sorry, to prove that.
To prove compliance with the RPS requirements.
Madam Hearing Examiner, EPE objects to this question again to the extent Ms. Stevens is asking Mr. Novella about legal ownership prescribed by this statute. That's a legal question.
Miss Stevens?
Oh, I agree, Madam Hearing Examiner, but it's in his testimony. If he testified to it, I want to know whether he's representing the company's position.
I think he's answered the company's position multiple times now.
No, he hasn't as to ownership.
Well, I understood Mr. Novella's testimony with respect to ownership, and that that his testimony was originally prepared prior to the amendment of the rule with respect to DG ownership.
He's talking. I hate to quibble. He's talking about use of the RECs to comply with the RPS. He's not talking in terms of ownership. There is a difference. And I'm asking what the company's position, not as a matter of law, because we may differ on that, but what the company's position is as a matter of policy. Who's a policy witness here?
This is a policy. Ms. Stevens, this is a policy.
This is a policy. He is a policy witness.
I think we'll allow one more answer to this question. I really also think that you've asked it several times. I feel that Mr. Novella is providing the same answer, but you may ask it this last time, and then I'd ask that you move on, Ms. Stevens.
Is it EPE's position that regardless of what it can retire, it still owns the RECs, all the RECs created by a distributed generation facility?
The only RECs coming from that amendment will be, again, the excess net RECs that EPE can register and retire. So that'll be a much smaller than percentage than what you're used to or what I'm used to being able to claim, register, and retire. Mr. Martinez, that percentage, then you may be able to ask him, and that may give you more details in regards to the question.
Thank you. I have a very quick question about your position throughout your testimony on yours and Mr. Martinez's. It comes up a few times about the Macho Springs PPA reallocation option. And is it correct that the total Macho Springs portion that's allocated to Texas that might be available for reallocation to New Mexico is a bit over 110,000 megawatt hours per year?
Off the top of my head, I don't know the energy for Macho on a jurisdictional basis, just the capacity. And that would be a 50 megawatt facility, 10 megawatts that are jurisdictionalized for the state of New Mexico and 40 megawatts for that of Texas.
And when you talk about this potential reallocation, it comes up several times in your testimony and again in Mr. Martinez's testimony. Are you talking about reallocating the entire Texas portion, which is roughly 80%, as we know, or a smaller portion, potentially a smaller portion than the entire amount?
Those detailed questions with regards to the energy coming from Macho from Texas to New Mexico, and I would say for Mr. Martinez, he may have ran different sensitivities with regards to your question, different percentages. I'm not entirely sure if that was provided, but so I can't answer that.
Let me ask that as just a kind of a policy thing, because I think that's what you're testifying to. You understand that if the commission were to consider a Macho Springs reallocation, that it would be necessary, first of all, to get the Texas Public Utility Commission to consent to that?
We would need their approval. Yes, that's my understanding. That's the case.
And is it the company's position that they would be able to get approval from Texas for less, that they would be able to get approval for Texas to allocate less than the full Texas allocation to New Mexico?
Let me look at my testimony. I don't see a breakdown, but I believe it would be for the entire Texas jurisdictionalized portion of the facility.
Let's move on to the large customer charges issue. And I take you to your rebuttal testimony, page 29. And that one's conveniently numbered, I think the same way. No, maybe. Actually, am I looking? Wrong case. So that one does not have page numbers. It just has the date stamping. We need to ask the hearing examiner to figure this out in the future. Now, the way I understand your testimony, your direct testimony, and your rebuttal testimony, Mr. Novella, is that the company provided notices to the customers, and now in your rebuttal, you're talking about billing errors. Is that right?
I don't follow your question.
Well, let's start over again. On page 20 of your direct, you say that the City of Las Cruces opposed company's treatment of past treatment of large cap customers. Let me find the exact language.
I'm sorry, Council, what page and which page number?
Now the page 20. This would be page 20 of your actual 20. It's 36 of 821.
Okay, I'm there.
Okay. It is actually at the very bottom of 19 onto page 20. And you state that in case number 21-00111-UT, the city challenged the payments by certain large customers from the effective date of the REA amendments to January 1, 2021, when the revised rider rate was amended. Do you acknowledge that the city also challenged those payments in case number 19-00099, UT, Mr. Martin Novella?
They may have.
And are you familiar with the order and the certification and stipulation?
I'm sorry, please repeat. Are you familiar with the order?
Order and the certification of stipulation in case number 19-00099, UT?
Yes.
Does EPE stand by the testimony that it gave in case number 19-00099, UT?
You need to send me to a page and I can see what you're talking about.
Well, does the company not stand by testimony?
Well, it might be testimony that's older, just kind of like the Q&As we had earlier about the amendments to the Rule 572. I don't want any misunderstanding with regards to.
I have not put a copy of that document, that order, in the list of exhibits. So I'm going to have to just ask you if to do hypothetically, okay, and we'll be able to check it against the order. And if the commission addressed that issue in that stipulation, in that certification of stipulation, by reference to testimony given by the company that said that it would be able to address the issue retroactively, would that still be the company's testimony?
Madam Hearing Examiner, I'm going to object to that question. One, it was complicated, and I think there are a lot of compound assumptions in it. And two, Mr. Novella's already answered his position about adopting testimony from the past stipulation.
Okay, I'll stop there. I'll just quickly ask you to look at the tariffs, the actual tariffs that were in place those years, and those are CLC exhibit number 7 and CLC exhibit number 8. And you go actually to the tariff sheet. I think it's a one page tariff in each case. Do you see the applicability provision on top?
On which of the two?
Well, either one, they're identical. I happen to be in exhibit 7.
Okay, I'm on 7, the applicability section.
Yeah. And do you see that the third sentence? You want to read that?
The third sentence?
The third sentence in applicability, it's where the X's are.
Where the what?
The X's are, you can pick them out by it starts with where the X's in the right-hand margin are.
With Regulation Commission?
This writer is applicable.
Sorry, that's the fourth.
Yeah, let's go to this right. That sentence in that row is the third sentence. This rider is applicable to all customer classes consistent with the New Mexico Public Regulation Commission NMPRC Rule 17.9.572.7 M and NMAC.
Okay, see, sorry, that was the fourth sentence.
Okay, with me?
So the fourth sentence that starts with this writer?
Yeah. And so are you reading that sentence that I started reading?
Let me read it now. Okay, I read it.
Okay, so that refers to the limitations of section 62.16.4A2 applicable to certain non-governmental customers. Is that the statute that we're talking about that changed the treatment of such customers?
Are you talking about the large cap customers?
Right.
So what happened in the 2019 amendments was that the large cap customers was ordered to go away essentially.
Right.
And EPE filed in that year actually to do the same with regards to its REA plan in that same year of 2019 to comply with the statute change that eliminated this large cap, and EP was ordered to withdraw their motion to remove this large cap provision. And they were asked to only supply a rider for the following year that took into account the over collection for the previous year. And that previous year was a 2018 reconciliation. So yes, I'm aware it happened in 2019, that change. EP asked to do the same with regards to its filing, but we were asked to remove that and refile with, again, only the taking into account the over collection from the previous reconciliation year.
And do you believe that the language of either of these tariffs, CLC 7 or 8, gave customers of a certain size a right other than the statutory right?
I don't understand your question. Can you restate it?
Yeah, so since the tariff refers to a statutory limitation and the description refers to customers subject to they call it a statutory cap. Once the statutory cap was eliminated, as you just said it was in 2019, were there still customers who were eligible for the statutory cap?
Okay, I think I understand your question. So although the statute changed, there were not updated commission approved tariffs at that point in time. So EPE has to bill based upon whatever commission approved rates our tariffs are in at that time. And again, EPE asked to remove this large cap in that fall and was ordered not to include it as part of the rider for the following year. EPE then again asked to remove this large cap in the following year in their amended application, and that was approved, but because of the timing of the REA, that wasn't able to take effect until the following year, so the start of January 2021.
And did the company ever define that cap provision or eligibility for that cap commission as anything other than being based on statute?
Can you restate your question or restate again? I'm sorry.
Does the company define in the tariff itself? Does it define eligibility for that treatment as deriving from something other than the statute?
I'm not sure I understand your question.
I'll just let it go. I'd like to move to admit CLC Exhibit 7 and CLC Exhibit 8. I think they're buried in Mr. Provencio's testimony, but they're easier to find here.
Any objections to CLC Exhibit 7 or Exhibit 8?
Madam Hearing Examiner, I think these are documents on file with the commission, and so I have no objection.
I do have a question, Ms. Stevens. Are those X's that you discussed part of the original document?
Those X's, Madam Hearing Examiner, are one of the rules for filing new tariffs, is that a utility is supposed to put an X in the margin on the lines where they're changing something from the prior version of the same tariff.
Okay.
So, and this I believe, let me see, I think I probably, I'm not sure. It's, you know, if you go to the first page of these things, they say file in the office. I'm not sure. I'm not sure whether I pulled these off of the commission's website based on the date on which they were filed, or whether they might have been filed as compliance filings in the individual cases. But this would be, as you know, as you can see in the first page of the cover sheet page, this would be as filed with the commission. And this would be what the commission kept on file, you know, until they were superseded by the next one. So if you go into
are there any other comments or objections relative to these exhibits? Okay. Given that there are no objections, CLC Exhibit 7 and 8 will be admitted.
Thank you. I'd like to move on to back to your rebuttal testimony, Mr. Novella, and move on to this. And I'm on page 12 of 43 of your rebuttal. And I'm on the paragraph beginning on line 10. Are you with me?
Yeah.
Yes.
12 of 43?
12 of 40, yes, 12 of 12 of 43 plus a lot of extra zeros.
Yes,
Line-
I'm on that page.
And leading into this, you're basically arguing that that this should be approved, that the carnet should be approved under the renewable energy rule and not under rule 551, correct?
So EP properly filed under 572 for various reasons in this Q&A, but it was under the RCT. It was a lowest cost portfolio twice, initially when they went out for RFP and also after the BAFO, the best and final. Also, if you read the language in 572, expressly says that facilities under this rule are energy facilities with or without energy storage. And this facility has energy storage, so it properly fits the rules with regards to 572. And if you look at 551 further, it says that it excludes facilities approved under the REA. So yeah, for a multitude of reasons, it makes sense that this type of facility is filed under the 572, and we did that.
Okay, so let's take a hypothetical situation, Mr. Novella. Let's assume that EPE solicited, did an all source RFP for capacity, for renewable energy, for demand side management resources, for renewable energy, big one, and the results of that were to bring the company, would have brought the company to 80% renewable energy instead of 50 or 60%. And would that have been a project maybe twice as big as Carne?
Well, I'm not sure. You lost me on the question, but
Okay, well, so a hypothetical is you go out to bid on an RFP, you come back with something that has the result of getting you to 80% of the RPS requirement. Is it the company's position that because that came out of an RFP process, that the commission would have to approve that proposal as long as the levelized cost of energy was less than $60 adjusted for inflation?
Well, there's
Madam Examiner, I'm going to object to this line of questioning. It calls for speculation. It assumes evidence not in the record, and quite frankly, it's compound and has a lot of assumptions and multiple parts in there.
I'm going to sustain the objection. Go ahead, go on, Ms. Stevens.
We'll do it based on the actuality of the situation. In this, would you look at Mr. Martinez's supplemental testimony, if I can find it? Well, since Mr. Martinez's supplemental hasn't been admitted yet, let me go to his rebuttal. Oh, Madam Hearing Examiner, did you admit my two tariffs? I'm sorry, did I?
Yes, exhibits 7 and 8 were admitted.
Now I'm going to exhibit 4, which is Mr. Martinez's rebuttal. We're back to page 13 of 34, that table VM1R.
I'm sorry, you said CLC exhibit 4?
4, yeah.
I'm sorry, isn't it EPE exhibit 4, the
EP,
rebuttal
yes.
testimony of Mr. Martinez?
Correct.
Okay, let me close this one and go to that one. EPE exhibit 4?
EP exhibit 4, Mr. Martinez's rebuttal, page 13 of 34. Although my
Okay, I'm on 13 of 34.
So what EPE is proposing in this case is the addition of the Carne project, which according to the projected RPS line on that table, brings EPE to a 58.9% RPS in 2026. Is that right? Are you with me?
Yes.
So is it EPE's position that that under the REA, it can go out and acquire any project that costs under the $60 as adjusted for inflation, as long as it contributes to meeting or exceeding the RPS? And here you're meeting or exceeding with 58.9%. That's my question.
Okay, well, I think it's a question that's best for Mr. Martinez with regards to how EP selects and the process, as well as other witnesses such as Mr. Wayne Oliver. But again, back to a previous question you had asked me, and we talked a bit about going above this minimum. And again, they're minimums. We can go above them, and we're financially incentivized to do so based upon the rule. I'm not surprised that it goes above that. But that being said, I would imagine that Mr. Martinez looks at a variety of items, such as need for our overall system, for the jurisdiction, and those all play parts with regards to selecting a procurement. And you also are or need to file a lot of these items with regards to an IRP, an integrated resource plan. So there are a lot of there's a lot of regulation and rules with regards to what type of facilities we seek to procure, and those would be best for EP witness Martinez.
This is a policy question, Mr. Novella, and I think you're talking about policy. In my question, and you're also talking about incentives, but I'm talking about, is it the company's position that when it has any project that it selects, it can come in and prove that as long as it adds to RPS compliance, got any bit of renewable energy attached to it, it can come in and file it as a program plan, an RPS program plan addition. And as long as it proves that the cost is under $60, that's the extent of proof that needs to be made in the case.
Madam Hearing Examiner, I'm going to object to this question again. Similarly, it's calling for hypothetical speculation and assumes facts not in evidence, and it's a compound question.
Ms. Stevens, do you have a response?
It's asking him what the company's position is on a really simple question, whether the REA is a way of avoiding the requirements of 551 or the CCN statute. I think it's that simple.
Well, actually, I think that I didn't actually understand the question to be asking that specifically, but I would say that I believe as the question was presented, to my understanding, it's already been answered by Mr. Novella, who testified earlier that he understands the REA to provide a floor as opposed to a ceiling, so that the 40% requirement in 2025 doesn't limit, but that the utility, in his opinion, can provide excess renewables under the REA.
Okay, thank you. Let me move on then. Is it Mr. Novella, is it your position that once the company make such an application under the RPS rule, that the commission is required to approve it if it falls under the $60 per megawatt hour RCT renewable cost threshold?
Well, it's multifaceted, like I said. There's that threshold, and again, in this project, we're below it, and it's a lowest portfolio cost. So you look at multiple things. And another thing that I think we need to look at or think about is the word reasonableness. You brought that up earlier, kind of asking me a question about reasonableness. And I think about that as, is it reasonable to go above the percentage, the minimums? Yes. And you did various hypotheticals at much higher levels. And I think that's a discussion that we have, and that language is within the rule for a reason. And again, I think these are very reasonable levels to go above that 40% minimum, because eventually those 40% become 50%, and our service territory is growing with regards to sales. So we have to add these types of facilities to meet these RPS requirements.
Your answer included an assertion about the lowest portfolio cost. Is that the lowest portfolio cost on a company-wide basis or on a New Mexico basis? New Mexico ratepayer obligation basis?
Let me check my testimony.
Ms. Stevens, we're just about at an hour, I believe, in terms of your cross-examination. Do you have an estimate as to how much more cross-examination you might have for Mr. Novella?
If he can find things, it'll take me maybe 3 minutes less.
Okay. Well, why don't we plan on taking a break for lunch when you've completed your questioning, Ms. Stevens, which then I would think would be no later than noon.
Yeah, definitely. Thank you.
Thank you.
Can't find that distinction, so
well,
save that for EP witness Martinez.
Okay.
And
actually, let me very quickly ask you whether the end of the paragraph that we're looking at, still on my screen, page 11, page 12 of your rebuttal. Because I want to ask another question about this paragraph that begins on line 10 with however.
I'm sorry, I had left that page.
Oh, I'm sorry. This is hard. This is hard.
Can you please direct me to where you are?
I've cut off your face for the last few minutes, and then it sounds like I don't want to look at you or make eye contact because there are only so many screens a person can look at at once. So you're back to page 12 of your rebuttal.
12 of 43.
12 of 43. Right. And I'm just wondering whether that last sentence in that paragraph, beginning on line 15, is helpful to your answering the previous question. If it's not, we'll just move on.
Yes, this is what I was referencing, that it was the lowest cost twice, the original RFP and in the second round, once they asked for refresh pricing. In BAFO, the best and final, they were again the lowest, from my understanding.
Okay, so that's and now you mentioned in the rest of that paragraph that actually line 12, the record demonstrates that it meets the Rule 550 criteria for approval. Would you turn to City of Las Cruces exhibit number 6, which is
if I could read this paragraph you just said, right? Said starting on page, or that same page, line 10, right?
Yeah, that paragraph there. And I just would, you say that basically you're saying that even if the commission held you to the 551 standard, you would satisfy it. Is that what you're saying?
So what I'm saying is that under 572, we're properly satisfying all the criteria, and we know it's the proper place with regards to seeking this type of procurement. However, if the commission deems that it should be under 551, we've met all the criteria under a 551 as well. So in order to limit costs and another procedure, another hearing, ideally would just be satisfied and finalized in this hearing, ideally under 572, but again, we met all the criteria under 551.
Second. And would you look at Rule 5 now that have you got 551 open, please?
Can you point me to an exhibit?
But yeah, this is my COC Exhibit 6. And are you there?
I have the document open.
Okay, well, I'm sorry, this is a weird document. It came off the New Mexico Compilation Commission, and they have a funky format. But I'm starting on page 3, which has the Section 8 general requirements for application for approval of a long-term purchase power agreement. And you have to go rolling down there. And if you see that one of the elements of the proof, and this is all the way down to line 5, is number 6, evidence that entering into the LTPPA is consistent with the provision of safe and reliable electric utility service at the lowest reasonable cost, considering both short-term and long-term costs and all other relevant factors. Is that, where is the evidence? What do you consider to be the evidence in this case for that point?
Yes, it's my understanding that under the PPA, that agreement and the ESA agreement, it provided a wealth of information just and answered all of these points. Now, with regards to where exactly it's located, I'm not sure.
Do you believe that the company has shown that it needs Carne to meet the renewable energy standards, or it needs Carne to meet its system capacity needs?
I believe it's both, and EP Martinez can answer that question. But I believe when that RFP went out, it went out from inception as to be a resource that can be used under this REA. And also, I believe there was a requirement for energy and capacity.
And one last question on the question of incentives, financial incentives, which you've mentioned several times. Is the company asking for financial incentives in this case in connection with Carne?
No.
Thank you. That's all I have. Thank you, Madam Hearing Examiner, for letting me go over a little bit. Appreciate it.
Okay, thank you, Ms. Stevens. I would ask that you notify Mr. Reyes that he's free to watch the hearing on YouTube, but should
Oh, is he
not.
on? Oh, there he is. Oh, I'll let him know. We're
Okay,
take lunch break, right?
Yes, we will take a lunch break, so we will reconvene at 1 o'clock. So we're going to go off the record. Thank you.
Thank you.
Hey, Alan, I just sent you an email.
How are you, Mary Lee?
I'm good, thanks. I just wanted to give you a heads up. I just sent you an email.
Okay. There it is. Okay. Will do.
Thank you.
All right, we're ready to go back on the record in the matter of PRC 22-00093. We had finished right before lunch with cross-examination by the City of Las Cruces of witness George Novella. I wanted to ask if it would be helpful to the participants if I were to put the exhibits up on a share screen as they were being discussed. To
It
the
would not
extent.
be helpful to me.
Okay. You're on mute, Ms. Stevens. Ms. Stevens, you're still on mute.
I know. Thank you. I'm sorry. I'm trying to get the mouse to the right place on the screen. I agree with Ms. Souls that I'd rather see people's faces than the screen share. I know it takes a little time, but and plus the burden of having you not just find the screen, but find the right page seems unfair.
Well, I'm doing it anyway, but okay. All right.
May I ask, Madam Hearing Zimmer, how many screens have you got in front of you? I'm
Just two.
Okay.
Just my laptop and then one other video screen. So anyway, all right. So I believe next, Ms. Souls, you would be cross-examining Mr. Novella. Mr. Novella, you're still under oath? Go ahead, Ms. Souls. If you
Thank
have any
you.
questions, of course.
I do have questions. Good afternoon, Mr. Novella.
Good afternoon, Ms.
I'm Mary Lee Souls. I'm a pro se party in this case. I'm going to ask you to go to your direct testimony on page 30 of 821. Let me know when you're there, please.
Okay, I'm here.
Beginning at line 4, you indicate that El Paso Electric has experienced global supply chain issues. What supply chain issues has El Paso Electric experienced related to the Buena Vista and Hecate projects?
Sure. So generally as an economist and as anybody living in the current times, we all see these kinds of issues. But to your question, being specific to the project, I think that'd be best for EP Witness Martinez. He might be able to give you more detail specific to those items as they relate to the project.
Very well. I don't recall that he said anything about those two projects or about supply chain issues. Are you sure you want to refer that to him?
Yeah, I would definitely ask him about those, but just generally, I could speak to supply chain issues and the disruptions, and we've all seen them, I think, again, in our daily lives, prices increasing, volatile or big swings in inflation and inflationary pressures impacting all of us in one way or in another. And this project isn't immune from those types of issues and pressures.
So you're not going to reference anything in particular that El Paso Electric had to purchase for those projects and the execution?
That's right.
Very well. Please go to page 37 of 821.
I'm there.
At line 17. Is it your testimony that El Paso Electric's 2021 RFP was primarily to meet the 40% RPS by 2025?
I believe it was multifaceted from a request point of view, where the RFP asked for a facility that met the REA as well as energy and demand requirements.
So is your answer then that it was not primarily to meet 40% RPS?
I think no, I don't agree with that. I would say that, again, it was part of multiple requirements taken together. So one resource that not just satisfied the REA compliance, but also can provide the needed energy and capacity requirements that EP Witness Martinez can testify to.
Any of those requirements primary, or were they all equal?
I would ask that of EP Witness Martinez.
And on page 38 of 821.
Okay, I'm there.
And I'm not. At line 12, you are describing the significance of the proposed procurement as a dedicated resource. How does El Paso Electric service only a specific customer with a dedicated resource?
I'm sorry, Ms. Souls, when you said that question, there was a loud noise that didn't let me hear one or two of your words. Do you mind restating?
I will ask it again. How does El Paso Electric service only a specific customer with a dedicated resource?
Sorry, one more time, please.
Is it because I'm not loud enough, clear enough?
No, it's very clear, but the middle of the sentence, I kind of lost you on a few of the words there.
Your testimony describes servicing a specific customer only with a dedicated resource. How does that work?
Oh, the customer?
How does El Paso Electric service a dedicated resource to a specific customer only?
Okay, I understand now. Yeah, so several large customers, and large customers can, and I typically see this large, they will request a facility for just themselves. So it is a facility that's completely dedicated to that one customer. And you tend to see this again with large governmental or industrial customers, where the facility generally nowadays we're talking about a solar facility, maybe a solar storage facility. It is completely dedicated to that one customer, and the associated costs as well are recovered from that one customer.
Would the NMSU project be an example of that?
Yes, that's a dedicated solar facility.
And it was my understanding that the output of that facility is subtracted then from El Paso Electric's total retail sales. Is that what you were saying would happen with Carne?
Let me think about how we structured that specific resource. At the moment, I don't recall exactly how it was structured if we're doing a subtraction of their overall retail needs. But
I didn't do that.
there's some piping noises that'll come here once in a while. So I apologize. But can you restate your question? But again, I can't speak to the NMSU contract right now off the top of my head.
I'm trying to understand what you mean by servicing only a specific customer, in this case, New Mexico, with a dedicated resource.
Okay, so as I mentioned with the dedicated customer, some governmental or large customer customers of ours, they seek a solar facilities or solar and storage paired facilities so that they can have those resources serving them specifically. And in return for that type of facility, well, they pay for all of the costs associated with that facility. Now, with regards to the Carne project, it would be a facility as well, in this case, also solar and energy storage that is built to only serve one of our jurisdictions, and in that case, the state of New Mexico.
Then what is the mechanism EPE is contemplating so that New Mexico doesn't duplicate resources? In other words, that the Carne serves New Mexico first and only the remaining requirements are serviced from other resources. How do you prevent the duplication?
I'm not sure I follow your question, but I think that your question can lend itself better to EP Witness Martinez and how they now, it used to be that when we did resource planning, it would be, I think, easier from the perspective that it was done at the system level. And now with all of the requirements that we're seeing now and the requirements we're seeing specifically out of the state of New Mexico, now they've bifurcated and broken up that process into different jurisdictions for how they plan and do the resource planning. And I believe Mr. Martinez can best answer that.
Very well, because that is exactly what I'm trying to understand, is how you do it separately rather than both New Mexico pays for system resources and it pays for Carne and nobody else does pay for it. Mr. Martinez can respond to that.
Yes, he can help with regards to how we now have to plan at a jurisdictional level versus that of a system. And I do talk a bit about those complexities in my direct testimony, and it's just the nature of a utility that serves multiple jurisdictions that have different types of goals and mandates, and in this case with regards to renewable energy.
So Mr. Martinez, just so we're clear, I'm not asking how you plan for it. I'm asking how you serve New Mexico and keep it separate.
Yes, I think that would be best answered by.
Very well. On page 39, I think that's the next page, at line 4. You do say that the full cost of the energy supplied by the dedicated facility will be recovered from New Mexico customers. Is that correct?
Yes, since it's a dedicated facility, just in the examples we talked about, if it's one customer or an entire jurisdiction, if that resource is built and used for that one individual customer or state, they would also pay the full cost for that resource.
And how do you, EPE, propose to reduce the cost burden on New Mexico customers for the existing generation that they won't be using?
I'm not sure what you mean by existing generation that they won't be using. I think that, again, these questions could best be answered by EP Witness Martinez, but I think that question lends itself more to a static view of resource planning and holding load constant. But as you plan for resources and you do it going forward, going out 20 years or so, you have to look at a world where need is changing, need is growing. We have increasing forecasts, electrification, these items that are changing, not just the way we consume energy, but the amounts of energy we need. And I don't see any issue with EPE or areas of concern we're having idle or non-used generation. I see that there's need there. So I believe EP Witness Martinez can answer those types of detailed questions.
And from a policy perspective, it's not your expectation that El Paso Electric would reduce the cost burden on New Mexico customers as a result. Is that correct?
I don't understand your question, ma'am.
So this is going to be paid for only by New Mexico customers. That's what you said. Am I right?
This dedicated resource will be paid for by New Mexico customers, yes.
And all of the shared resources, do you anticipate any reduction of the cost to New Mexico customers for the shared resources that New Mexico will not be dependent on?
With regards to costs, again, I would refer to EP Witness Martinez, but what I would say is that it's hard to give you an answer because we're talking about projections and how we will have costs, or the cost will be derived for customers. And with regards to New Mexico's share of EP's overall generation mix and usage of that mix, there's a lot of hypotheticals going out into future years and how,
of course,
how New Mexico will use and consume energy, how fast they will, or slowly they will alter their overall forecast that we have for them. There's a lot of moving pieces, so it's hard. I can't tell you exactly how their costs will shape over time.
And from your perspective, you don't anticipate a reduction in those costs. Am I correct?
Which costs specifically are you talking about?
The cost for the shared system resources that currently exist.
Yeah, again, I would talk to EP Witness Martinez as we're getting into the detail of the cost for these facilities.
Very well. Let me see where I want you to go next. I want you to go to your rebuttal testimony at page 10 of 43, if you'll let me know when you're there.
I'm there.
At line 9, you say that you will rebut these arguments from a regulatory perspective, and that Mr. Hopkins and Mr. Martinez rebut these arguments from a resource planning perspective. Is that correct?
Yes.
Would you please explain what you mean by the distinction, regulatory perspective from resource planning perspective?
Sure. So the way I understood it, and if we go through my testimony, essentially that it applied and fully applied with the needed criteria to file for a new procurement under the Rule 572. That's the way I understand regulatory compliance. And with regards to the detail about resource planning or any of the questions that relate to that area, you can reference EP's Witness Martinez as well as Hawkins.
All right, so you're suggesting I need to ask Mr. Hawkins and Mr. Martinez about my resource planning question.
Yes.
Okay, please go to page 11. At line 16.
Okay. Same document, right, ma'am?
Yes, it should be. I think it's the next page.
What line, ma'am?
Line 16.
Okay, I'm there.
You state that EPE filed for approval of the Carney project as part of EPE's 2022 REA plan as a necessary component of EPE's plan to achieve its renewable and clean energy goals. Is that your testimony?
You left off some wording, ma'am, but I think it says to make reasonable and consistent progress towards the REA renewable and clean energy goals. Yes.
And am I correct that the 2022 REA plan is specifically about the 2023 plan year and the 2024 next plan year? Is
No.
that correct?
No, although when you do a plan, the next year's the rate year, and for illustrative purposes, you give a secondary year, but you properly, if you want to recover or seek procurement of a facility under the 572, it's a lengthy process, as we all understand, seeking approval of a generating resource. It's not a quick process. It's not something that we can undertake in a fast manner of time. So it's proper to request it now so that it could be properly in service by 2025 and serving our New Mexico customers, as well as satisfying our higher 40% RPS target.
And am I correct? Carnegie doesn't change anything in 2023. Is that correct?
Well, the project wouldn't go online till 2025. So there would be no energy coming from that project.
No energy coming from Carnegie prior to 2025, correct?
I'm not sure the exact month, if for specifying the exact month when it's expected to go online. I would ask EP Witness Martinez, but I believe it's before the summer of 2025.
Very well. And if Carnegie were not required for El Paso Electric to achieve the 40% renewable energy by 2025, would you still claim that it should be considered in a Renewable Energy Act filing?
I'm going to object to the question. That's not EPE's position.
Ms. Souls, do you have a response?
There's all kinds of testimony in this case about whether or not it's required for the 40%. And therefore, he just told me that it has to be dealt with in this filing. So I think we have to talk about that.
Well, you can ask him about EPE's position regarding the current project.
Go ahead.
Is it EPE's position that if Carnegie were not required for El Paso Electric to achieve 40% renewable energy by 2025, would you still claim that it should be considered in a Renewable Energy Act filing?
I'm going to renew my objection. That's EPE is proposing Carnegie in this project, in this application.
Right. I mean, that seems somewhat speculative, Ms. Souls. I'm not sure what the purpose is of this line of questioning.
The city and I have made it an issue as to whether or not this is a Renewable Energy Act procurement or it's a capacity procurement. And that's what I'm asking. So if it weren't required to satisfy the 40%, is it El Paso Electric's position that it should still be proposed and considered as a Renewable Energy Act filing?
I'm going to sustain the objection. This is asking for speculation.
Very well. If Carnegie had to be delayed and couldn't produce renewable energy in 2025, what then?
I'm going to make the same objection to speculation.
Madam Hearing Examiner, the 4 procurements that are renewable energy procurements and that are critical to El Paso Electric achieving 20% renewable energy in 2023 and 2024 have all been delayed past their forecasted start dates. So I think this is very relevant to ask what happens if or when Carnegie is delayed past its projected start date of May 1st, 2025.
I think, Ms. Souls, you can ask Mr. Nometfela whether or not EPE has a plan in the event that the Carnegie project does not go online in 2025.
Very well. Mr. Novella, if Carne does not achieve its May 1st, 2025 projected commercial operation date, does El Paso Electric have a plan to meet its 40% RPS?
Well, so to be clear, that is our plan for Carne to be online by 2025, not only to meet our 40%, but also to help meet the cumulative rec deficiencies that we've had and discussed in year 2020 and 2021. However, we have offered in the past, and we've mentioned it in this case in my direct testimony, that we've brought up the idea of bringing up Macho Springs with regards to a temporary transfer of recs from that Texas portion of Macho Springs to that of New Mexico. However, again, I don't think that's needed in this case because we're seeking Carne to be compliant with the 40% requirement in 2025.
And if the Macho Springs proposal were to be put in place, what would that cost New Mexico ratepayers?
I'm not sure.
Who would know?
I'm not sure we've done that analysis, and I'm not exactly sure what it would entail to produce what you're asking for.
And would Macho Springs represent additional energy as well as additional recs for New Mexico?
Yes, you would be transferring over the about approximately 80% jurisdictional portion of Macho Springs, which is about 40 megawatts out of a 50 megawatt facility, over to New Mexico. So the energy and the recs associated with that facility would be used by the state of New Mexico.
And how does that actually work? Does that reduce some other energy that New Mexico is relying on and that then Texas would use?
Like I said, that hypothetical is difficult when you look at it forward looking, because it might be that New Mexico, and it generally is, has more load requirements every year going forward. So as I do a load forecast and I project New Mexico, if we were looking at statically, you could say that maybe there would be some type of resource that doesn't get used because it's being replaced by that 40% or 40 megawatt Texas jurisdictional portion of Macho Springs, but that's not the case. We're going forward looking, and when you look forward looking, the state of New Mexico has growth, and because of that, I don't see a hypothetical where it's not being used. But for those types of questions, I would give them to EP Witness Martinez. He might have ran an analysis that can answer your question.
Am I correct that when Macho Springs or any other facility generates renewable energy, that those electrons don't actually get tagged so that you can make sure they go to New Mexico rather than Texas, that isn't something you're able to do?
You can properly tag them from the perspective of accounting so that the proper entity can pay for that resource.
So you would be able to, more Newman 5 energy goes to Texas in exchange for Macho Springs energy going to New Mexico. Is that what you're suggesting?
I'm talking about accounting treatment with regards to making sure people pay the proper cost. Are you talking about the actual flow of electrons from a generating facility to an end user, say a house?
I'm trying to figure out how the flow of electrons in these words dedicated to New Mexico or supplied to New Mexico, how do those words translate into financial accounting?
Oh, okay. So for jurisdictional facilities, there's going to be a thing called allocator, and there's different types of allocators, and they allocate a percentage to total. And in this case, for what you're asking, it could be what we hear quite often, an 80-20, meaning that New Mexico is about 20% and Texas is about 80% of our service territory. Well, you apply allocators to an overall facility so that for accounting and financial analysis, you can properly break apart costs and properly account for cost and cost causation to our customers.
And so am I correct that El Paso Electric is asking for cost recovery in this proceeding for Carne?
No, my understanding is that we're just seeking approval of procuring this facility.
And where do you anticipate that the cost recovery dynamic would take place?
In the writer, the RPS writer.
And so El Paso Electric anticipates that Carne would be an RPS rider cost?
It's definitely under the description of a facility that's part of the RPS, which clearly says a renewable energy facility with or without energy storage. And that properly defines the Carne project, which again, it's a 130 megawatt solar facility with a 65 megawatt energy storage portion. And because of that, it would properly fit under Rule 572 of the REA. And as such, it would properly be recoverable under the RPS rider.
And Mr. Novella, are you familiar with the Buena Vista 1 and the Buena Vista 2 projects?
Yes.
And are you also familiar that the Buena Vista 2 costs, which were approved in a renewable energy filing, are rate rider, RPS rider costs, and Buena Vista 1, which was not in an REA filing, is not RPS costs?
Yes, and that makes sense because they were approved in different procedures, different filings. As you said, Buena Vista 2 was approved under the REA, so properly it should be allocated, or the cost should be collected through the RPS rider. And the Buena Vista 1 project was approved in a LTTPA or a 551, and as such, it shouldn't be recovered in a RPS rider.
Then why wouldn't Carne look more like the Buena Vista 1 as a capacity project?
So capacity-wise, they're both capacity projects in that they both have a capacity component, but I believe the Buena Vista 1 was a part of an RFP with a lot of different projects, and they were all system facilities. And there was no requirement, I believe, at the time for REA with regards to recs for these projects. And this project from its inception has been an REA project where the RFP entailed a requirement for REA as well as energy and demand component.
So Mr. Novella, are you saying that Buena Vista 1, when it was approved, that it was not a consideration that it was needed for RPS requirements? Is that what you're saying?
You would have to best ask EP witness Martinez exactly how that RFP was laid out for specifics, but they're entirely different. Although at surface level, you'll see some similarities with regards to a energy component and a demand component. But again, the Carne project is being put under 572 from its from its inception because it's being asked to, I'm sorry, one of the requirements is that it falls under the REA in addition to capacity and energy. And I believe the 551 project that you bring up was, again, a system resource that was used to fulfill overall retail load need, not, again, an REA resource from its initiation. And because of that difference, they were filed in separate locations, the 551 versus a 572. So the 572, I believe, in this case is proper.
And has El Paso Electric ever met its 20% renewable portfolio standard requirement?
So El Paso Electric has always been considered compliant since the initiation of the REA. With regards to the 20%, we have always, again, had compliance.
I thought you were always waiting for retroactive recs. Is that not correct?
So we've been compliant, but again, we've been compliant with retroactive recs for the 2020-21 year, and that was under one plan year that was truncated together, the 19 and the 20 plan. And then again, further one more time where the commission approved future excess recs to fill a previous year's deficiency in 2022. So we're compliant for all of those 3 years.
Would you please go to page 12 of these 40? Wait a minute. I don't know which one I'm in. I'm in the rebuttal. Okay. At line 20 on page 12. You're asked what impact the Carne project will have on the financial condition of the company. Do you see that?
Yes.
Please explain how a purchase power agreement and an energy storage agreement have a financial impact on El Paso Electric?
So I think the takeaway from this Q&A, and I can't name all the intricacies with regards to financing and how they interact or with your question, but I can tell you that based on the project costs and our overall financial position, the takeaway would be on line 1 of page 13 there, where the proposed Carne project is expected to have minimal impact on the financial position of the company. And then there you get to see in the following lines our overall assets and obligations.
And Mr. Novella, what part of the project costs will be borne by El Paso Electric?
I'm not sure if any of the costs, exactly how they will flow to EP itself, but from my understanding, the project would be collected by its New Mexico customers through the RPS rider.
And those are the project costs you're referring to?
No, there might be some other costs that I can't think of currently that EP has to take on as a part of this project.
So was there any purpose to this question?
To me, it's a question of risk as you take on these types of large facilities that, can be pretty costly. That what happens if you start on a facility like this, maybe don't get commission approval. These just overall questions of risk if a company can handle that type of risk, and that's what it lends itself to.
Then would you agree that all of that risk that you're concerned about would be borne by the New Mexico ratepayers?
Risk? Well, to me, it's not a question of risk as much as a question of there's a law and a mandate with regards to 572 of hitting certain goals. And there's a goal to hit a renewable target in 2025, and this asset is going to be used for that. Now, in terms of a risk, I don't see a risk because that asset will be used by customers. The overall service territory for New Mexico is seeing growth with regards to overall consumption of energy and demand. So I don't see a risk of a situation where you have a facility that is not being used. So just generally with the question, I don't see a risk component around this.
And are you referring there to a risk to El Paso Electric?
Both El Paso Electric and our customers.
And if El Paso Electric doesn't meet its 40% RPS in 2025, what's the risk to El Paso Electric?
Well, if we don't meet our compliance, that would be up to the commission to see what exactly would occur. But ideally, like I said, we will meet our 2024 or 2025 goals through our 40% RPS with the Carne project.
And has the commission ever applied financial penalties for the utility not meeting its obligations like that?
I'm not sure.
Let's go to on page 12 at line 15. You reference El Paso Electric's claim that the Carne project is consistent with El Paso Electric's IRP. Are you familiar with El Paso Electric's IRP? Yes,
I take part in it, not at a level that EP Witness Martinez does, but a smaller portion.
Then if you would, let's go to Souls Exhibit 5. Let me know when you're there, please.
What page on the document, ma'am?
I'm going to ask you to go to page 25 of 390, but let's confirm you recognize this as El Paso Electric's 2021 Integrated Resource Plan?
Yes.
And you would agree this is the most recent commission accepted integrated resource plan that El Paso Electric has filed?
Yes, I believe it's the most recent.
And so every time you or other El Paso Electric witnesses reference that the Carne project is consistent with the 2021 integrated resource plan or other references, this is what we're talking about. Is that correct?
Yes.
And are you at page 25 of 390?
No. Okay, I'm there now.
You see this table 6, incremental resources portfolio additions for New Mexico.
Yes.
Do you agree that this represents the resource portfolio additions that the commission accepted as El Paso Electric's 2021 IRP?
I'm not familiar with the table. Like I said, this document, it lent itself more to EP witness Martinez. So I would say questions in terms of tables and detail of the document for him.
Okay. Are you yourself familiar with anything different that you would say was the IRP resource portfolio additions that the commission accepted?
I'm sorry, I didn't hear the end of that. The IRP resource portfolio.
Additions that the commission accepted.
I'm not familiar with the detail of the tables or docs. So I can't answer your question.
Very well. And would you please go to page 31 of 390?
(31), ma'am?
That's what I have written down. I'm trying to get there myself. Yes. Do you see the 2021 IRP 4-year action plan?
Yes.
And do you see the last bullet in this list? Has El Paso Electric filed for abandonment of units that are past their useful life?
Madam Hearing Examiner, I'm going to object to this question as outside the scope of this proceeding.
Ms. Souls?
Yes, ma'am. The integrated resource plan is based on how El Paso Electric forecasts matching demand with generation resources. And this 4-year action plan and the abandonment of units are very directly related to the requirements for generation, renewable or otherwise generation resources.
I'll allow it, but we do need to see how this relates to the existing proceeding that's before the commission.
So my question, Mr. Novella, has El Paso Electric filed for abandonment of units that are past their useful lives?
With regards to questions on abandonments and their useful lives and those types of questions, I would say those for EP witness Martinez.
Very well. Let's go to page 38 of 390.
I'm there.
All right. Table 7 here that represents El Paso Electric owned existing generation stations and fuel types. Does El Paso Electric generally equate planned retirement dates as equivalent to a unit being past its useful life?
Again, this type of question would be best for EP witness Martinez.
Very well. Do you see the units that have planned retirement dates prior to 2023?
Yes.
And which ones are those?
On this table, table 7?
Yes, please.
Rio Grande Unit 1, Rio Grande Unit 7, Newman Unit 1, Newman Unit 2. That looks like all of the ones that have a date under the column plan retirement date before 2023.
And just to clarify, you said Rio Grande Unit 1. Do you mean Rio Grande Unit 6?
Yes, you're right. Unit 6 and Unit 7 under Rio Grande.
And do you see the footnote at the bottom that says Rio Grande Unit 6 is subject to a pending abandonment proceeding in case number 20-00194-UT?
I see that footnote, yes.
All right, so would that say to you that at the time of this filing that was already underway, the proceeding regarding abandonment of Rio Grande Unit 6?
Again, you'd have to ask these questions of EP witness Martinez. I'm not sure where, if they are at in that type of process.
Very well. Madam Hearing Examiner, I'd like to move for admission of Souls Exhibit 5, El Paso Electric's 2021 Integrated Resource Plan.
Does any other party have an objection to admission of Exhibit 5, Souls Exhibit 5?
Madam Hearing Examiner, again, this is a document that's on file, and so we don't have any objections to it being admitted.
Hearing no objections, Souls Exhibit 5 will be admitted.
Thank you, ma'am. And Mr. Novella, please go to your supplemental testimony, page 4 of 9.
Okay, I'm there.
Beginning at line 13, you're describing how excess RECs in future years can be used to make up the shortfall of RECs in 2020, 2021, and 2022 to meet the 20% RPS. Is that correct?
Yes.
And you referenced the stipulation adopted by the commission in 22-00111-UT, correct?
Two cases in the question. There's the case before 2020, 22-00111-UT. In the question, you also have 19-00099. So both of those cases.
Do either of those cases limit how far into future years that excess RECs can be used to make up a shortfall in 2020, 2021, or 2022?
I don't recall a limitation on future, but as you see the testimony of EP witness Martinez, he has a table to show how long and by what year it'll take us to recover or to satisfy previous year's deficiencies by year. And I think that table is very helpful with regards to that question, because it shows that, with Carne, we're able to satisfy cumulative deficiencies by 2025.
Yes, sir. I'm not asking about the resource plan. I'm really asking you about, is there any limit to how far in the future? If the RECs were generated in 2026, could they still be used based on those two cases and the decisions that came out of them?
My understanding is yes. And the only reason I brought up the table was at least it puts a cap on how far out we expect to go with regards to satisfying those types of deficiencies.
All right, so there's not a limit in future years, if I understand your testimony. Does the stipulation address shortfalls in any year beyond 2022?
My understanding that shortfall that was described in that case was specifically for 2022.
So a shortfall in 2023 or 2024 would require a new plan or a new determination by the commission. Is that your understanding?
I would think we would seek approval for an additional year where we would use excess RECs, but that's not something that we're requesting in this case. In this case, we're actually going to satisfy all our REC needs for this year to the point where we actually have excess RECs, which is very nice. And we're now able to start filling in some of those previous year's deficiencies starting in this year, 2023.
Yes. Please go to page 6 of 9.
I'm there.
At line 17, you are discussing the impact of the new standard regarding DG Rex, correct?
Yes.
Ms. Solz, are you on page 6 of 43 of Mr.
I'm on
Novella's?
page 6 of 9 at
Of-
line 17.
Of what document?
The supplemental testimony, ma'am.
Oh, thank you.
Mr. Novella, what is your understanding of when the commission's changes that are coming out of case number 20-00158-UT, when would those take effect?
As staff witness Tupler recommended, and we agree, those would take effect, and we would use them if they were active or in next year's plan. So they would be taking effect into next year's rate year, which would be 2024.
Is that Mr. Tupler's opinion, or is that yours and Mr. Tupler's interpretation of the commission determination?
That's my opinion on what should occur, because that amendment, it recently occurred and it's not active yet. I think it would be proper for us to have the current treatment proceed through the remainder of this year. And for the next filing, EPE can make that change if it gets finalized and instituted.
Would you please go to page 7 of 9?
I'm there.
Please explain the other option that you reference here.
So with regards to the question, just kind of trying to answer or provide options for meeting our RPS requirements and thinking of things that we haven't filed for. One option that we haven't raised is EPE proposing a new REC purchase program for EP's New Mexico DG customers. This isn't something that's gone beyond any surface level kind of discussion or analysis, but just something I thought I'd mention.
So you or EPE believes that there may be ways that you could rehabilitate the New Mexico DG Recs so they could be counted against the RPS?
Possibly mitigate that drop, but again, that's all hypotheticals, and it's gone nowhere beyond just some surface level discussions. I just wanted to include it as part of this response because that's something that had crossed my mind.
And so you talk about help mitigate the drop in RECs. And you also say that even with that, it would not eliminate the need for new renewable energy procurement. What assumption did you use about how many DG RECs we're talking about in 2025?
Yeah, so if you think about it, we were recovering a certain number of RECs, which was really all of them, 100% RECs before this amendment. And now after this amendment, if it gets approved and instituted, we're going to recover a much smaller amount. Now, if we were to have a REC purchase program, hypothetically, and it was such a good program that you get all of them back, you're back to what you had at the beginning. So that's essentially your ceiling, is back to your original scenario is your most optimistic with regards to how much you can buy back. And under that scenario, which is what we've submitted here, because what we submitted here was before those amendments went through, we still needed the Carne project, even with the original methodology for being able to register and retire RECs. We needed that. So under the most optimistic scenario of this option I bring in, we will still need Carne to satisfy our 2025 needs.
And how many DG RECs is that's included in that forecast for 2025?
I'm not sure on the exact count. You'd have to ask EP. Witness Martinez, I'm sure he has those on his tables.
Very well. Ms. Novella, I have no more questions for you. Madam Hearing Examiner, thank you very much.
Thank you very much, Ms. Souls. Mr. Downs, any questions?
No, Madam Hearing Examiner, I have no questions for this witness.
Thank you. Mr. Herman, does Doña Ana County have any questions for Mr. Novella?
Yes, Madam Hearing Examiner, I've got, I don't think I'll take a whole hour, but I've got a couple questions.
Go ahead, Mr. Herman.
Good afternoon, Mr. Novella. How are you doing today?
Good, yourself, sir?
I'm doing well. I don't know if we've had the pleasure of meeting, but my name is Keith Herman, and I'm outside counsel with Doña Ana County. I just had a couple questions to clarify some of your direct and rebuttal testimonies. If you could go with me to page 9 of your direct, and that's the Bates number 25, otherwise page 9.
Okay.
Let me know when you're there.
I'm there.
Okay, so starting at about line 14, you are describing El Paso's system as about 2,576 megawatts. Is that the entire system or just the New Mexico allocation?
Entire system.
And then I think you move on and identify some additional customers. You state that there's a steel plant in White Sands. I'm sorry, I did not write that page number. Oh, here it is. It's up above that. Actually, started around page 7.
Yes, sir.
Or, I'm sorry, line 7. Besides White Sands, which of those customers are located in New Mexico?
We have a large medical center in New Mexico, one of the large universities in New Mexico, and the military installations, as you mentioned. Those would be the customers as part of this list, sir.
Okay, thank you. Now, under cross-examination with Miss Stevens earlier today, you mentioned that El Paso Electric is incentivized to exceed RPS standards. Do you recall that?
Yes, sir.
And you also discuss it in your rebuttal at page 13, line 19.
That's correct.
So what incentives were you specifically referring to when you mentioned that?
Yes, yes, sir. So the Rule 572 has a section on going above and beyond the RPS minimums, so those percentages, and that there would be some type of financial incentive along with exceeding those goals for the New Mexico utilities. So just a general reference to that.
Okay, was that the only incentive you were referring to?
Yes, sir.
And is it El Paso Electric seeking any of those financial incentives in this proceeding?
No, we are not.
Excuse me. You had mentioned under your cross-examination from Ms. Souls that New Mexico is in a state of growth. Would it be fair to characterize EPE's markets both in New Mexico and Texas as growing in energy demand?
Yes, it would.
And my understanding of some of Ms. Souls' cross-examination did go into the resource planning phase for additional load growth and whether or not current costs of service. I'm sorry, scratch that question. Let me just ask you, were you involved in EPE's last rate case?
Yes, I was.
Did you provide testimony in that case?
Sorry, I'm struggling hearing you. There's a noise that'll stop in a bit.
I just asked if you had provided testimony in the last rate case.
Yes, I did.
Okay, I'm sorry, then we have met before because I was involved in that case too. Do you know if El Paso is anticipating another rate case soon?
It's hard to say. We have models with regards to when we anticipate our regulatory forecast, but from what I understand, that's pretty fluid. So if there would be one, the soonest it could be would be in 24 for a 23 test year, but that's not for certain. It could be pushed back.
Okay. Okay, my last section or my last area of questioning is going to Macho Springs, which I believe you addressed in your direct testimony, starting at page 25. And the question I have for you is on page 26, where you discuss the possibility of reallocating an additional 30 megawatts to the New Mexico jurisdiction. And that's page 42 on the Bates numbering.
Okay, that's correct.
Are you seeking approval of that proposal in this proceeding?
No.
Okay. All right, I'm sorry. I have one last question about the Carne project. Is EPE seeking approval from either Texas or I guess the city of El Paso on that project?
No.
And you had done some discussion regarding seeking approvals on a jurisdictional versus a total system basis. As New Mexico moves forward in its pursuit of carbon-free energy, do you anticipate that we are going to see more resource procurements on a jurisdictional basis?
Yes.
All right, I think that's all the questions I have. Thank you very much.
Thank you.
All right, thank you, Mr. Herman. And finally, staff, Mr. Borman or Ms. Regensburg.
Good afternoon, Gloria Regensburg. Hello, Mr. Novella. I don't think we've met. I'm Gloria Regensburg. I work with the legal division staff.
Oh, nice to meet you.
And I just have a couple of questions. I'm going to ask you about your testimony in Exhibit 1 on page 69 of 821. It's the PDF page 55, if that's easier to get to.
Almost there.
Okay.
69 of 821.
Yes, correct.
I'm
So
done.
if you look at I think it's the second full paragraph on December 16, it starts, and you mention the Supreme Court decision in case number S-1-SC37458. And you're talking about, the history of the remand, and it came back to the commission in case number 18-00106 UT. And you mentioned the fifth revised rate number 38. Do you see that? Kind of a summary of the paragraph. Yes. Okay, so is there a copy of that revised rate or the advice notice in the application anywhere?
I'm not sure.
Okay, well, I didn't find one. So I was wondering, and I don't know how to do this procedurally, Madam Hearing Examiner, but would it be possible to get a copy of that and enter it into the...
Oh, I apologize.
Olson?
I was just going to say that if I recall correctly, EPE made a compliance filing in the docket. And so that document is on file with the commission and available on eDocket.
Okay. Yeah, it's on, it is filed in 18-00106. I was just curious if it was in the application. All right. Well, that's all I had. Those are all my questions.
Okay. Well, I believe if there's any need to discuss that, Ms. Regensburg, you could certainly reference it in briefing.
Okay, thank you.
You're welcome. Ms. Olson, do you have any redirect? Well, actually, I do have a couple of questions.
Madam Hearing Examiner, I'm sorry, a little slow on the uptake here with my mute. Regarding that last ruling that you just made for Ms. Regensburg, what are the standards here in terms of administrative notice of past commission filings as opposed to orders? Because I was under the impression, maybe I'm mistaken, that that except for commission orders, which would be orders, not filings by the utility, that we need to at least get administrative notice taken, if not actually getting a copy into the record for the hearing examiner. I'm just
I would have to check on that, Ms. Stevens.
Yeah. I mean, but there are two levels of the question there. One is whether you need to take administrative notice, and the second is whether it goes into the physical record, the record
For this case.
for purposes of appeal and everything like that.
Well, to go into the record, it would have to be an exhibit.
Yeah, so okay.
All right, so anyway, continuing. So Mr. Novella, I just had a couple of questions. I just want to clarify that, in fact, if El Paso Electric needed to utilize Macho Springs, that would be requested in a separate proceeding. Is that correct?
That's correct. We're not seeking that in this filing.
And your testimony is also that you're not requesting, I think this follows up on Mr. Herman's question. Actually, I think that's all I had. Thank you.
Thank you, Madam Hearing Examiner.
Novella. Ms. Olson, do you have any redirect?
Madam Hearing Examiner, I do have very brief redirect. Good afternoon now, Mr. Novella. Ms. Stevens asked you about requirements that were in the final order issued in case number 19-00349 UT. Do you recall that?
Yes,
And she directed you to look at paragraph 33 of that order, which was in what CLC had designated as Exhibit 5. Do you recall that?
yes,
And to save you from having to go back and look at it, it's the finding from that final order that said EPE should be ordered to provide in its next application for approval of any resource acquisition, whether by CCN or long-term purchase power agreement, a comprehensive plan showing how EPE will comply with the renewable energy and zero carbon energy requirements of New Mexico law. Does that sound familiar?
yes, it does.
Does EPE do regular resource planning?
Yes, they do. They do it regularly in this type of proceeding where you have annual filings for the REA. And on a long-term basis, they do it in the integrated resource plans. Now, with regards to that short-term and that long-term resource planning, if there's any additional information that the commission needs, we'd be happy to take that into account and help where we can.
And so to unpack that testimony a little bit, is it your understanding that that comprehensive plan showing how EPE will comply with renewable energy requirements, was that provided in the IRP?
Yes, I believe the IRP goes out to 2045.
So is that your understanding that between the annual Renewable Energy Act plan filings and the IRP that EPE is satisfied that finding in the commission, in the prior commission order?
Yeah, yes, I do.
And then you said something about additional information.
Yes, if on a short-term basis, we're seeing annual filings with regards to resource planning and in this type of proceeding with regards to our RPS, and going out on a long-term basis, we're seeing an IRP. But if there's any other type of information that the commission needs, we'd be happy to look into it and try to satisfy that.
And then I believe Ms. Stevens also asked you questions about EPE's needs for the Carne project. Do you recall that discussion?
Yes, I do.
And does EPE or EPE's resource planning needs reflected in the IRPs?
They are.
And I think when you were talking with Mary Lee Souls, you agreed that the 2021 is the most recently filed IRP.
It is.
And that was accepted by the commission.
It was.
Okay. And then finally, Ms. Stevens asked you about previously filed tariffs when you were talking about the large customer adjustment issue. Do you recall that?
Yes, I do.
And she had you look at CLC Exhibit 8, which I believe was entered into the record.
Yes.
Do you have that CLC in front of
I
you?
don't think it was. Here. I don't think the hearing
You
examiner.
moved for permission.
It was.
It was okay. They are in Mr. Provencio's testimony.
Exhibits 7 and 8 were admitted.
Are admitted? Thank you. I need more organized.
And do you have that exhibit in front of you, Mr. Nobella? CLC Exhibit 8.
I do.
And can you tell me the date that that was filed?
December 2nd, 2019.
And I believe the first page of that is a cover letter. Is that correct?
That's correct.
And is it your understanding that this advice notice was submitted pursuant to an order by the commission?
It was.
And that's the, I believe it's the November 18th, 2019 order that's reflected in that cover letter.
Yes, that's what it reflects.
And if you go to your rebuttal testimony, EPE Exhibit 2, and on page 30 of 43, you talk about that November 18th order, is that correct?
I do.
And what did that November 18th order require?
The removal or to withdraw our proposal to remove the large cap and to only keep in for the rate rider, the over collection from the previous reconciliation year, 2018.
Okay, and so there was a previous advice notice filed to CLC CLC Exhibit 8, is that correct?
That's right.
And is that the October 1st advice notice that's discussed in your rebuttal testimony on line 9?
Correct. That's the one that we filed where we asked to remove that large cap.
And then CLC Exhibit 8 is the new advice notice you reference on line 18, is that correct?
Yes, that's correct. That's the one after we're asked to withdraw the large cap provision. So it reflects that November 18th date that you mentioned.
Okay, thank you, Mr. Novella. Let me just check my notes. I believe that's all the redirects that I have.
Thank you, Ms. Olson. I guess in response to the question with respect to whether or not I think fifth revised rate number 38 that was raised by Ms. Regensburg should be an exhibit referencing 1.2.2.35 of the New Mexico Administrative Code. Section F, official records such as final orders can be referenced without being made exhibits, but other portions of administrative proceedings under paragraph D3 should be in the form of exhibits. So Ms. Regensburg, if you would like to submit that as an exhibit, please do so. And
Okay, thank you, Madam Hearing Examiner.
you're welcome. All right, I believe that we would be finished with Mr. Novella as a witness today. Is there anything further?
Yes, don't we get to recross on the redirect?
Do you have redirect on the recross, Ms. Stevens?
I have questions to follow up on Ms. Olson's questions for Mr. Novella. They're not many. And the first one I would like to do is in the subject of the tariff filing that Ms. Olson and Mr. Novella just talked about, the December 2nd tariff filing in case 1999. And I'm sure that Mr. Novella is not going to recall this, but I would like to, the city raised an objection to that. And
testifying or
I'm sorry, I'm not hearing Miss Olson. Go ahead, please.
I'm objecting to Ms. Stevens testifying into the record. This does not sound like a question.
Ms. Stevens, what is the question?
Okay,
please?
well, Mr. Novella, you just testified about the December 2nd, 2019 filing of El Paso Electric in conjunction with the first tariff that it proposed in case 19-00099 UT, correct?
Is that Mr. Novella? That would be a question for you.
That's
With regards to our first filing, what was that second part of the question?
Ms. Olson just asked you about the fact about the December 2nd replacement to the December 2nd, 2019 replacement tariff filing and the November 18th, 2019 order that preceded it.
Yes, you did.
And I am. This is not. And what I like to ask you about, except that my screen is not showing, is, do you recall, were you involved in that case at all yourself?
No.
Did you review it? You did. You mentioned earlier when I was cross-examining you that you did review the old cases, the last couple of cases.
Yes, I did. I went
Okay.
right through.
Are you aware of the fact that the city objected to that advice notice number 264 that you and Ms. Olson were talking about?
Yes, on that same page of rebuttal testimony, page 30 of 43, line 20, on December 17th, the city filed objections. Is that what you're referencing?
Yes. Now, do you know whether the commission ever ruled on that objection?
I don't believe they did.
Okay, and then let's go back one. Okay. Let's go back to the IRP itself. The it's Ms. Souls exhibit number 5, please. And
sorry, I closed that one. So let me just.
Yeah, me too. No, I hear you.
Okay, what page?
No, I'm going, well, let's see. No, my question to you is, I don't have a specific page and I'd like you to tell me where, let me go back to my notes on what you testified to, where in that document it shows a need for 130 megawatts. First of all, 130 megawatts of solar paired with 65 megawatts of battery storage coming into service in the year 2025. Can you show me that?
I'm not sure where the document it shows exactly that, but what it does show, it details going out, at least to 2040, a detailed need and discussing in detail the RPS and how we're going to be compliant with regards to marrying the RPS as well as our overall resource needs. So all of that information is in that document. But if you want to,
let's try to get a little more. Let's try to get a little more specific. Novella, you've said repeatedly that there's a plan in there, and that your filing is compliant with that plan. Show me where in here there's a need for 130 megawatts of solar paired with 65 megawatts of battery storage.
I'm not sure where or if that's specifically in here, but this details out year by year or going out how we're going to meet our resource needs. And in addition to not just meeting our resource needs, but meeting them through also following the REA. So it's a detailed, very large document. I can't go through it and find that exact portion that you're requesting. I'm not sure, but Mr. Martinez could help you with that.
It's your testimony that it's consistent. Please do your best.
Hearing examiner, the questions asked and answered twice.
Ms. Souls, I'm sorry, Ms. Stevens, do you have a response to that?
Well, okay. Shall I ask him whether his testimony is unsupported because he cannot find what he relied upon? I think I'm asking him to do his best to point to what's.
Well, I think that Ms. Souls, Mr. Novella has not necessarily had the opportunity to memorize exhibit 5, Ms. Souls exhibit 5. I don't think that this is a question that can legitimately be asked at this time. Is there a reference to Mr. Novella's testimony that was discussed during his redirect examination?
Yes.
Okay, and
Yes.
what page is that of Mr.
Well,
Novella's?
she, during his redirect, Ms. Olson asked him, let me see if I write fast when I'm not talking. So Ms. Olson brought him to MLS Exhibit 5. He recognized it as the IRP, that it was the most recent accepted one. And regarding the phrase consistent, his own phrase consistent with the 21 IRP, this is the document he means. And she said, let's see. I'm sorry, here. I'm in the wrong place here. But actually, no, it's more than that. Ms. Olson asked him if the comprehensive plan required by the final order in case number 19-00039 was provided in the IRP, and Mr. Novella said yes, and that they've satisfied that requirement with the IRP. So I'm asking, where is the comprehensive plan in this IRP that shows the need for Carne?
Again, I think the entire document taken as a whole, if you just do searches within the document for REA, 2040, renewables, you're going to see them hundreds of times. Just the whole thing is a comprehensive plan around how we're not going to just meet our native system load, but meet it while at the same time being compliant with the REA. And the whole document has this type of language throughout. So I'm not going to point to you one specific section. It's a over 300-page document. But again, if maybe Mr. Martinez can point you to a table that'll help you. But the whole document, I could point in various places, and we'll talk about REA and renewables and those types of wording.
So is the company's position that any sort of vague plan saying that we have needs over the next 20 years is enough to justify and satisfy specifically all the requirements of the REA and the Renewable Energy Act and any other applicable commission or rule or New Mexico statute that says you have to demonstrate that your proposed acquisition is consistent with your IRP?
Well, I definitely
Madam Hearing Examiner, I'm going to object to that question and the characterization of the 390-page IRP as a vague document. I think it mischaracterizes the plan. It mischaracterizes Mr. Novella's testimony.
Ms. Stevens, do you have a response?
If it's not vague, they should be able to point me to where the need for Carne is specified.
If Ms. Stevens wants to give Mr. Novella time to read the 390 pages and identify every instance that's supporting his testimony, then we can take that time.
I think that there's an opportunity for addressing this document in briefing relative to Mr. Novella's testimony. And I think that's an issue that the parties can discuss.
I guess this goes, I'm sorry, I shouldn't be interrupting. I guess this goes to the credibility of Mr. Novella's testimony. I would like him to also tell me where, this is in that, if he can, where in that document is, because this is what I have for other witnesses, where in that document is there a need for 121 megawatts of any sort of capacity in 2025? Can you do that, Mr. Novella?
For detailed questions regarding the IRP and the numbers that you're kind of describing, I would save those for EP witness Martinez.
Okay, and the same would go for the 175,000 megawatt hours of renewable energy that's mentioned in the RFP. Or
with regards to any type of detailed questions like that, the subject matter expert would be EP witness Martinez.
okay, I will ask Mr. Martinez and possibly Mr. Oliver as well. Thank you, Mr. Novella. Appreciate it. Thank you, Ms. Olson. Thank you, Madam Hearing Examiner.
Do any of the other parties have any redirect? Office of the Attorney General, Ms. Souls, Mr. Downs, Doña Ana County, or staff? Or I'm sorry, recross.
Not I, Madam Hearing Examiner. This is Alan Downs.
Thank you, Mr. Downs. All right, if there is no further recross, I believe Mr. Novella can be dismissed at this time.
Thank you, Madam Hearing Examiner.
Thank you, Mr. Novella. I think we can take a 5-minute break at this time while EPE prepares its next witness. Ms. Olson, is that?
Yeah, Madam Hearing Examiner, that would be great. We'll switch the witnesses out in the witness room.
Okay, so we will take a 5-minute break. We'll be, I don't know why my computer is showing it as 2:28 right now. So we'll reconvene at 2:35. So we're going to go off the record for 7 minutes. Thank you. All right, we are continuing in the matter of PRC number 22000093. I believe El Paso Electric has a witness, Victor Martinez. And Ms. Gonzalez, could you swear Mr. Martinez in, please?
Yeah. Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Martinez.
Good afternoon, Ms. Olson.
Will you please state and spell your full name for the record?
Yes, of course. My name's Victor Martinez. Victor, that's Victor, Martinez, Martinez.
And Mr. Martinez, what is your current profession?
Right now, I am the manager for resource planning, resource management, regulatory and quality assurance group for El Paso Electric.
And Mr. Martinez, do you have before you what's previously been marked as EPE exhibit number 3?
Yes, I do.
And do you recognize that document as your pre-filed direct testimony?
Yes, I do.
Was that direct testimony drafted by you or under your direct supervision? Uh-oh.
Did we just lose Mr. Martinez?
I think we may have. Let's see. Hey, Linda, are you on? Whoever's on for EP IT support, can you let us know what happened?
You may have lost them too.
Let us call him.
We'll call him real quick and try to figure it out.
Okay. You could go on mute while you do that, Ms. Olson.
Madam Hearing Examiner, I understand something happened in the hearing room and they're fixing it now, so it should just be a couple minutes.
Okay, thank you, Ms. Olson.
Madam Hearing Examiner, if I may, while we're
Yes.
waiting, I would
Yes,
note
Mr.
that
Foreman.
at least after one witness, we do not seem to be at a pace that we would finish this proceeding tomorrow. I'm wondering if there's any thought that's gone into how we address that.
I mean, I share your concern that this is the time that we have scheduled. I guess I would ask the parties whether they anticipate having as many questions for the remaining EPE witnesses as they had for Mr. Novella.
Madam Hearing Examiner, particularly for witness Victor Martinez, who Mr. Novella referred an awful lot of questions. I do expect to have quite a number of questions for him. For the other witnesses, probably not.
Madam Hearing Examiner, the same with me as Mr. Martinez. I had a lot of questions for him before, and he's received more. Poor man. I don't think I have, depending on whether Mr. Martinez can answer all the questions, I don't think I have too many for Mr. Oliver, but I do have a fair amount for Mr. Rodriguez, because he's got multiple, they're small issues, but there are a bunch of them. So.
Well, I think we can hopefully get close to completing Mr. Martinez's testimony today. I mean, one option, well, I think we'll just have to see how far we get today, and then tomorrow morning, we will have to discuss what options we have if we don't complete the testimony tomorrow, other than Ms. LaRoque. I mean, potentially we could have additional witnesses on February 16th besides Ms. LaRoque. That might be one option.
Is
Madam
Wednesday?
Hearing Examiner, is there an opportunity to start earlier tomorrow morning?
The problem is that we have the order published for 10 a.m.
I understand.
So I don't know whether or not we can reasonably change the start time for tomorrow at this point.
Madam Hearing Examiner, I suppose we're not going to get to the AG's witness this afternoon. That's what I'm thinking.
No, I think we'll be fortunate if we get through Mr. Martinez this afternoon.
Okay. I'm going to have to see how that affects her availability. I'm waiting to hear back now.
Well, if anyone would like to ask their witnesses if they are available on February 16th, I think, you know, we could look at that as an additional date for the hearing. For any witnesses that could be available that day.
Well, I know Ms. LaRoque is.
Yes. Any word from IT, Ms. Olson?
Yeah, could you check to see if he's in the waiting room?
Yes.
Okay, great.
Okay, Mr. Martinez.
Yes, I apologize about that. My computer just unexpectedly turned off and we had to reboot the whole thing. I apologize about that.
Okay. Did we complete your Ms. Gonzalez? Did we complete Mr. Martinez swearing in?
Yeah, and actually we had a pending question. Do you need it?
Yes, please.
Oh, give me 1 second. So the question by Ms. Olson was that direct testimony drafted by you or under your direct supervision?
Yes, it was.
And do you have any corrections to your direct testimony?
I do.
Can you please walk us through that correction?
Yes, of course. On page 42 of my direct testimony, on line 15, the word GN2 should be changed to GN1.
And that's page 435 of 821 if you're going by the Bates numbers.
Yes.
And with that correction, is your direct testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
And if you were asked these same questions today, would you give the same answers under oath?
Yes, I would.
And Mr. Martinez, can you, or do you have what's been previously marked as EPE Exhibit 4 before you?
Yes, I do.
And do you recognize this as your rebuttal testimony?
Yes, I do.
Was your rebuttal testimony drafted by you or under your direct supervision?
Yes, it was.
And do you have any corrections to your rebuttal testimony?
I do not at this time.
Is the rebuttal testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes, it is.
If you were asked these same questions today, would you give the same answers under oath?
Yes, I would.
And Madam Hearing Examiner, do you intend to enter Mr. Martinez's supplemental as Commission Exhibit 2?
Yes.
And
If
would
you-
you like to affirm that?
Yes, please.
Mr. Martinez, do you have the supplemental testimony that was filed this morning in front of you?
Yes, I do.
And was that supplemental testimony drafted by you or under your supervision?
Yes, it was.
And is the supplemental testimony true and accurate to the best of your knowledge and belief?
Yes, it is.
And if you were asked these same questions today, would your answers be the same under oath?
Yes, it would.
Madam Hearing Examiner, I'm sorry, I can't remember if we already entered that one into evidence.
Commission Exhibit 2, Mr. Martinez supplemental testimony? No. So is there any objection by any party to admission of Commission Exhibit 2, the supplemental testimony, Mr. Martinez? Hearing none, Commission Exhibit 2 will be admitted, as are Exhibits 3 and 4 upon the affirmation. Okay, anything further, or is Mr. Martinez ready for cross-examination?
Nothing further at this time. We intend for cross-examination.
Mr. Elliott, do you have any questions for Mr. Martinez?
I do just get two questions. Good afternoon, Mr. Martinez.
Good afternoon. Shelley.
My name is Gideon Elliott. I represent the Office of the Attorney General. I have a couple of questions just about the contract with Desiree. Am I pronouncing that right? Desiree?
Yes, that is correct.
The project's expected to go online in 2025, right?
Yes, sir. It's expected to go online May 1st of 2025.
Okay. So can EPE and Desiree negotiate a new COD date under the existing contract without going through the formal amendment process?
At this point, I don't believe we have. I think those have already been set in the PPA and ESA. So if something were to happen where we would have to change the COD, we may need to amend the contracts.
So it would have to go through a formal amendment process.
That is my understanding.
Okay. And with respect to the damages, do you know approximately what level of replacement power the damages would cover?
Yes, so I know with this contract, in order to make sure in order to assure that the contract that the project would be available by the COD that they committed to, we ended up putting a pretty hefty security on the project right now. Right now, I believe it's close to about $19 million security that we can actually collect from. And right now, we did actually put into the contract daily replacement costs that are equivalent to $200 per megawatt per day, which in the beginning for May, it'll be about $39,000 a day that Desiree does not meet the COD. The replacement cost goes up in June to, I believe, 300. In July, it goes up to 400. And then in August, it goes up to 600. So every month that goes by that they don't meet the COD, the replacement goes up, it goes higher. So it's really to incentivize Desiree that they're able to meet the COD.
And so does it, just out of curiosity, does it drop down in September?
Yes, it does. It would drop
Okay.
back in September.
All right, that's all the questions I had. Thank you very much, Mr. Martinez.
You're welcome. My pleasure.
All right, thank you, Mr. Elliott. Next up, we have the City of Las Cruces, Ms. Stevens.
Thank you. There it is. Moved on my screen. Mr. Martinez, my name is Anastasia Stevens. I represent the City of Las Cruces, and welcome to your first appearance for the PRC.
Thank you very much. Glad to be here.
Well, I'm not sure you're that glad after Mr. Novello deferred a whole lot of questions. Let me follow up though with where Mr. Elliott just asked you, and you said that the replacement damages would be $39,000 a day in May and increasing in the summer months. And then you said they go down. Is it correct that they not only go down, but they disappear after September? Is that right?
I need to double check. I don't think they don't disappear in September. They do go down, but it's simply because replacement costs in September would be lower than they would be in July and August.
What is your expectation of how much energy would come out of that project in a May day? Let's say in May. I know that there's a curve. I know that there's a curve, and typically April or May are the highest part of the curve, right?
You're absolutely correct. They are higher. I know through the year it's about 398,000, but I don't recall the actual months, the profiles of each month right now.
Have you ever looked at what the $39,000 based on megawatts would equate to? Well, what I'm asking you really is what market price would that correlate to? Would the damages correlate to? Very, very approximately.
Yeah, right now I don't recall the exact damages based on market conditions, but we thought the 39,000 should be suffice to be able to replace our replacement cost during those months. And just to be clear, the 39,000, it's actually the capacity for the 130 megawatt solar plus the 65 megawatt capacity for the battery. So it's 195 times 200 should give you about 39,000, I believe.
And I'm going to break all my rules in this examination and go to my very last questions that I had prepared because they're on the same subject of delay damages.
Sure.
Turn to VM, your direct testimony. I guess it is. No, it's your exhibit VM4 within your direct testimony, the contract, the energy contract.
Oh.
Within your direct testimony, and I'm sorry about messing around with numbers, but I never know which numbers with the footers of page numbers, the headers. It's very hard to tell, but I think I am at, well, what I was looking at is section 3.6 of the Carney PPA, and according to my, it's if you look at the, let's see, it's the upper corner. Maybe if I could maybe help everybody by going down to the it's 484 of 821 of the Bates numbering. Probably just misplaced by. Are you with me?
I'm sorry, I'm in
It's
3.6.
let's see, I'll look at it. It is page 4. It's labeled, the footer at the bottom says 484 of 821.
Oh,
Um,
okay, I'm there. I believe I'm there.
or within the contract that top. Okay, so you there is, and I'm looking at section 3.6. This is the purchase power agreement, not the storage agreement, right?
I believe so. Yes.
Okay, and do these do sections 3.6.1 provide that there will be no delay damages if on a data excused for a day-to-day basis for any event of force majeure? It would be 3.6.1A.
Yes, I do see that. It says that the expected commercial operation date and related delay damages provisions under section 3.7 shall be extended by a number of days on a day-for-day basis up to, and then list one of them, I believe it does, list 100 days equal to a duration of any force majeure event.
Okay. And then it also, the subsection B there does the same as far as the day-to-day extension without damages for a interconnection delay. All right.
Yes, I believe so. Yes.
And if we turn, okay, 3.6.2 discusses what an interconnection delay is.
Mhm.
And these are ones caused by the seller, is that right? The seller is DESRI?
That is correct. The seller is DESRI.
Now, who was the other party on the interconnection?
I apologize. I'm not sure I follow.
Oh, well, it says that let's look to 3.6.2, the portion of that section. It says that that it will not be considered. Let's look at what is a breach. Who's the transmission provider? Is that El Paso Electric?
Yes, it is.
And what does the subsection 3.6.2 two lowercase Roman numerals, breach of the interconnection agreement by the transmission provider? If EPE as the transmission provider breaches the interconnection agreement, does DESRI have to pay delay damages?
In this particular case, no, they would not. And it was just something negotiated by DESRI. But no, if there's delay due to maybe the interconnection not being in place at the time COD, they would not have to pay those daily damages.
And can we go to section 15.1 of this contract, which my notes say is page 64, which is probably the 64 in the upper right-hand corner, because those are the numbers I'm using.
Okay. I'm almost there.
It might be easiest to just put force majeure in there.
So I'm in Article 15 force majeure. I'm 15.
Great, you're faster than I am. Thank you. So looking at the list of force majeure events, there's a force majeure event is defined in 15.1.1, starts off with the list of a force majeure event shall mean any supply chain event, and then or other circumstances. And let's go bouncing through this contract one more time to find a definition of supply chain event, and that's up in the definitions on page 25 of the contract. Again, I'm looking at the 25 in the upper right-hand corner, but supply chain event. This is like follow the chain here. Supply chain event means any delay in seller's performance arising out of any import restriction action. Is that correct?
I'm not there. I apologize.
Oh, you're not with me?
Yeah, I'm slow this time.
Yeah, okay. If it helps, I don't know. It says, although it's got, it says 87 of 309 on the top bar for the PDF.
Yes.
That help? Does that help?
Yes, it does. I'm there, the definition now.
Okay. So a supply chain event means a delay arising out of an import restriction action. And can we go back up to page 16 to 17, which is, if we give me a second here, is pages 78 to 79 of the PDF, which is, I'm sure the hearing examiner is going to wonder about using the PDF numbers after we did all this date stamping. And does the import restriction action cover a lot of governmental action affecting imports of components of the solar facility?
I'm going through it again.
Yeah, no, please.
Okay. Okay, I'm there. Could you repeat the question one more time, please?
So now we're all looking at this definition. Does it include a lot of, it's a fairly broad grasping of import related restrictions? Now, given these provisions that we've just traced our way through, possible causes of delay would give rise to delay damages as opposed to would be excused.
Yeah, based on my understanding of the contract, if there were some issues that some force majeure issues that could potentially delay the COD, then DESRI would not have to pay the delay damages on force majeure events that have been set aside here on this document.
Okay, thank you. Now we'll go back to starting at the top where I meant to talk. Your resume indicates that you've got a lot of, you're in this case in a lot of different directions. Can you tell me whether you were part of the team that developed the RFP?
Yes, I was. I was part of the team that developed the RFP.
And going back even before that, were you involved in the 2021 IRP? Way too many acronyms here with the Integrated Research Plan.
I agree with too many acronyms, but yes, I was actually part of the team that helped develop the 2021 IRP.
So all the deferred questions to you, he did defer to the right person. Were you part of the EPE group that actually managed the RFP process as it was underway once the RFP was issued?
Yes, I did oversee that.
And were you personally involved in the bid evaluations of the initial bids?
My team was mainly the ones who did all of the analysis themselves. I oversaw the results and provided my comments for, and to support them throughout the process, but I'm familiar with it.
So you were involved in the selection of DESRI in the first go round?
Yes, I was.
And once that would happen, were you personally involved? I see for your back before you in this job, you did contract negotiations. Were you personally involved in negotiating the contract with DESRI after its initial bid was selected?
Yes, I was.
Were you personally involved when DESRI gave notice of its unwillingness to go forward in April?
I was involved when DESRI reached out to us to let us know that there was some changes to their initial bid, in essence. Yes, I was.
And am I correct in understanding that I think it's in your testimony, maybe it's in Mr. Oliver's, that they gave some sort of notification and then they did an actual indicative pricing sort of presentation a little later in the month of April. That's
Yeah, I believe it was April 22nd with Desiree provided a presentation, which in essence kind of provided a snapshot. It was based on the best information available at the time of what the cost of the projects would be based off, again, that time.
And would you please open up CLC Exhibit 14, which I hope is in your folder? That was the one that was circulated this morning. That's why I'm saying I'm hoping.
Yes. I'm sorry, what CLC was it again?
CLC 14 was the two that showed up this morning. That's why I'm saying you've got access to it.
I apologize. I don't see it on my side. It goes up to 13 only.
That's what I was afraid of. Ms. Olson, can you help?
Yeah, Victor, I don't know if you have a copy of it or the hearing examiner has offered previously to share the screen that you see it, but it's that one page from the Desiree April 22nd PowerPoint.
Okay.
I can share. I'll go ahead and share.
It might just be better to share the screen.
Yeah, you can just share the screen or email it to him, Carrie, if you'd be more comfortable.
I just prefer the screen because I don't want
Don't read the screen.
to have to check their emails. I don't know.
have my email here. In my email.
Oh, thank you. Excellent.
Okay.
I can see it.
Yeah.
I can make it a little bigger.
So
think
Mr.
this is-
Wilson, you're familiar with this presentation and this exhibit, I take it from?
Yes, I am familiar with it.
And would you agree that on April 22nd, Des3 suggested, I mean, I know this wasn't filed, but suggested increasing the energy PPA price from $19.29 to $28.25?
Yes, correct.
And the battery storage from $6.99 to $9.05?
Yes.
And we know that the final price is higher than this, both sides.
Yes, correct.
And do you see the note under the second dark green bar, the note number 1?
Yes.
That says the PPA price would be reduced in the event that the project qualifies for a 30% ITC.
Yes, I do see that.
Is it your understanding that the project now qualifies for a 30% ITC?
That is my understanding. Yes, it is.
The city moves to admit CLC Exhibit 14.
Madam Hearing Examiner, I have no objections to admitting this. But I just want to make it clear to make sure there's no confusion that this was previously designated as a confidential document. We've waived confidentiality to this single page of that document, but we maintain our claim of confidentiality for all other pages in this document, which are not being offered in this record, but just to clarify for anyone else who has access to the confidential document.
Any objections to admission of this CLC exhibit? Hearing none, I would say that I would prefer not to have non-consecutive exhibit numbers. So I would actually like to designate this as CLC Exhibit 6.
Madam, are you saying because I haven't used my existing 6 yet?
No, because I don't think what you have identified as Exhibit 6 is actually, a portion of the New Mexico Administrative Code.
Yeah.
And so therefore, I don't think it's appropriate to be entered as an exhibit.
Okay. Yeah.
So that's why I would use that number, Exhibit 6.
I'm just looking, I think I'm following you. You're kind of doing some infill, right? But
I'm backfilling. It's one of the themes of this.
Oh dear.
It's one of the themes of our case here.
Yeah. Now I'm just concerned about where that's going to leave us ultimately, because I did not admit CLC 5 because that was a final order.
Well, we could then designate this as
Use
Exhibit
5.
5. Why don't we
Okay.
designate this?
Madam
Yes.
Hearing Examiner, can I express my concern that in the transcript, I'm going to have a really difficult time knowing what we were referring to at what point in time as they've already been pre-labeled.
And
so the testimony up to this point is going to refer to this as CLC Exhibit 14, and then going forward, it's going to be CLC Exhibit 5, and we've already talked about CLC. I just, for my own peace of mind, and then I'm going to be able to follow the thread of all of what we've done, I am very worried about that.
Well, I will do my best to make sure in the future that we re-identify the documents earlier in the process, but I think we can work through this one document, Ms. Souls. So the DESRI April 22, 2022 presentation, single page document will be admitted as CLC Exhibit 5.
While we're in the same realm here, let's turn to what's been marked as CLC by me as CLC Exhibit 15, the DESRI May 13th, 2022 proposal.
Okay, hold on a moment and I'll pull that up.
And
So let's refer this as to CLC Exhibit 6, formerly 15.
Okay. So.
Okay, and I will put this on share screen.
And Madam Hearing Examiner, I just make the same clarification with this, that the city and NEPE reached an agreement to waive confidentiality of this single page of the document that was previously provided as confidential.
Understood. Thank you, Ms. Olson. Okay, and exhibit CLC Exhibit 6, formerly 15, which is a page from the DESRI May 13, 2022 best and final offer, is on the screen.
And then Hearing Center, can you make that small enough so that we can see the proposal as opposed to the letterheady stuff?
Yes. There you go.
Thank you. And Mr. Martinez, I trust and pray that you've seen this before, right? Last week when we were working on this. So, and would you confirm that this is the final order, that the final proposal bid that the company accepted after the best and final offer round, in which they went back to the other shortlisted bidders?
Yes, that is correct.
And again, I'll ask you to look at the note number 1 here. A little different from the note number 1 on the other.
Yes, I see it.
But again, in May 13th, this was issued. The bid was assuming a rate of ITC rate of 26%, and that's gone up to 30% now, right?
Yes, that is my understanding.
And no adjustments were made between May and October when you finalized the contract to reflect that change, were they?
I'm sorry, can you repeat the question? I apologize.
Between this receiving this bid in May 13th and reaching the final agreement with DESRI in October of this year, you didn't make any adjustments to the solar energy purchase price to reflect the fact that the IT rate had gone down, up, which means more money less cost to DESRI, right?
Well, I wouldn't characterize it as the fact of the matter is that there was a lot of things going on during that time. So so to just pinpoint it on the ITC, I feel we might not giving its full context, but just to answer your question, based on the 29.
I'm sorry, could you please repeat some of?
The sound is getting really bad here.
Oh, I'm sorry. Can you hear me?
I can hear you now. Maybe
That was
slow
better.
down a little so I can tell where one word ends and another begins.
Okay. Yeah, what I wanted to say is that there's quite a few things happened from May 13th through ultimately when the PPA was executed. So one of the things that happened is, again, during that time, we were noticing increases in polysilicon going up. We were noticing increase in lithium carbonate going up above levels you've never seen before. We noticed raw materials going up, such as steel, such as aluminum, such as copper going up. With inflation, interest rates were going on at the time. That was causing the project to go up. At the same time, there was a lot of regulatory uncertainty. At the time, the US was investigating the Southeast countries in Asia for circumventing or anti-dumping laws. So there were supply chain issues going on. There was also some panels, being held up in ports just to make sure that they were adhering to child forced labor laws. So again, a lot of things were being on. So ultimately, the price that we ended up accepting was a price that in essence took all of those things in consideration. And we ended up somewhat negotiating a fixed price with DESRI. That way they in essence assume all the price risk.
Okay.
And DESRI.
Now look at item 2 on this bid, the May 13th one. This says parties to discuss a mechanism to address battery system cost increases. So that is an additional, in your testimony, that is an additional open-ended or adjustable clause that was provided in there for at DESRI's request, right?
Again, it was based off of just negotiations between EPE and DESRI. With the negotiations, sometimes you will have some give and take. So while we were able to fix the price of the energy, we were able to also negotiate a price fluctuation as well, with DESRI on the price of the battery.
Madam Harris-Hammer, I'd like to move to admit this, if I haven't already, as CLC 6 and get it off the screen because we move on to something else.
Any objection to admission of CLC Exhibit 6, formerly 15? Hearing none, Exhibit 6 will be admitted.
And Madam Hearing Examiner, for the benefit of the court reporter, will you want me to relabel and resubmit these renumbered documents for the record?
I think yes. I believe so. Ms. Gonzalez?
Yes.
Yes, definitely. Okay.
All right, thank you.
You can give us the instructions, whether that's at the end of the hearing or at the end of each day. Thank you. So let's move on, Mr. There you are again. Moving squares, you know. Moving on to page 14 of your direct testimony. And I'm thinking I'm looking at one. This is actually the page on the page on the bottom in the middle, not the 400 page.
You're referencing page 407 of 821.
I am referencing page 407. Yes. Yes, I have it in my notes here. Beginning at line 19. And this is basically a question that I was going to ask you before, Mr. Novella. EPE issued its your testimony is EPE issued its 2021 IRP, which identified the need of 175 megawatt hours with associated RECs. You also say the long-term renewable energy resource was required to have a COD on or before May 1, 2025. I have two questions here. First, let's go to exhibit MLS 4, is it? 5. Miss Solz's version of the, other than mine, Miss Solz's version of the RFP is MLS exhibit 5. Sol's exhibit 5, I guess it's how she's labeled it. Sol's exhibit 5. Have you got that?
I'm opening it up. Yes, I have it up now.
Okay. And it sounds like you are more familiar with the 2021 IRP than Mr. Novella is. Can you tell me where, can you point out where in there it reflects a need for 175,000 megawatt hours for renewable energy purposes?
Specifically in this IRP?
Yes.
Well, like I said, it's been a while since I've looked at it. I'm not too sure exactly where the exact 175,000 number comes around. I know it was specifically listed in our RFP where we were requiring 175,000. I'm not sure if the IRP specifically gave that number. I'd have to go through it.
Well, your testimony is that it identified that number. So I'm asking what identified that number, how it identified. If it's not where, explain to me how it identified.
Okay, well, yeah, I can tell you the how. I mean, we simply looked at our jurisdictional sales for years 2025, from then compared it to all of the resources, EPE, all of the renewable resource that EP currently has and that EP currently plans to have. And based on the deficiency in 2025 of meeting the 40%, that's where the 175,000 came in. And yes. And I do want to say that those projections was based off of, I believe, the 2021 long-term forecast.
I noticed in your rebuttal testimony that you did not challenge Ms. Sol's CPU, Ms. Lisa LaRocque's estimate based on your tables that EPE will reach an RPS of approximately 38% in 2025. Do you challenge that?
Madam here. I'm going to object. I don't know that Ms. Sol's testimony is in evidence, but I'm not sure what Ms. Stevens is talking about.
Well,
Well, Ms. Stevens, is your point that Mr. Martinez did not address Ms. Sol's or Ms. LaRocque's testimony in his rebuttal?
that part of her testimony. I'm going to go through the numbers anyway. I just wanted to know why he, whether the fact that he didn't rebut it meant that he didn't disagree with it.
Well, why don't you continue, Ms. Stevens? Let's try to move forward as expeditiously as possible here.
So I'll ask that question quickly, and then if you don't worry what the answer is, because I will do some arithmetic. Did you not take issue with Ms. LaRock's testimony that you'd reach an RPS of approximately 38% based on Buena Vista, but based on existing resources plus the Buena Vista and Hecate in 2025?
Yeah, I can recall Ms. LaRoque's testimony at this time. Based off of my direct testimony, I know if we, based on table VM3, I show in 2025 would be about 49.8% with all the resources, including Carney.
Yeah. Okay, well, this raises another question here, which is now that you filed your supplemental testimony today,
Yes.
in Exhibit 3, is the table in there the latest and greatest and best approximation that I shouldn't be sarcastic here, but is the table VM, is the table VM1S on page 4 of 11 of your supplemental testimony filed today, is that the company's best presentation of what it predicts the future to be at this point in time?
At this point, yes, it is.
Okay, so we can skip over the alternatives that are in your supplemental testimony. This is the one that you adhere to.
Yes,
So,
I would agree.
and you did some calculations in your own testimony, rebuttal testimony about it's actually in the supplemental testimony. In the supplemental testimony, you did some calculations about what the effect would be if you remove that 265,562 megawatts from 2025. And I'd like to go over those again.
Yes.
So and this is the column on VMS 1S-1S 2025 column. So, and do you have a calculator?
I do not.
Can you find a calculator on your computer?
Madam Hearing Examiner, I'm going to object to asking the witness to do calculations on the stand.
I mean, Ms. Stevens, what are you trying
Well,
to get at?
I'll find. Let me find. He did he did a calculation in here. It's in his rebuttal testimony. Hold on a second. This is in the supplemental. Hold on 1 second here. Must be here then. Okay, the arithmetic is, some of the arithmetic is in your supplemental testimony at page 5 of 11 in the footer, page 3 of the document. You with me there?
I'm on page 5 of 11 of my supplemental, yes.
Yeah, okay. So this is your estimation of what would happen without Carne, that you would fall short of the 40%. Is that right?
Yes, it is.
And it ties into the exhibit table VM1S on the preceding page, correct?
I believe it's table VM2S.
VM2S or 1S?
I believe it's 2S on page 6 of 11. So table.
Okay. Well, we don't even. Let's just say, let's use VM2S. So you've and because here you've calculated 37.1%. But tell me, if you remove Carne, don't you have to remove the reduction for planned round trip energy losses of 10,400, which were part of Carne?
That would be correct. Yes,
So that 649,000 number should go up by 10,400. Is that right?
I would agree. Yes.
And if you, and how about the planned solar curtailments? If you have 60 in the year before Carne comes on, would you agree that most of that 9,296 would be attributable to Carne?
It's hard to say in reality, because again, curtailments are very unknown. And I think that's one of the things I do mention in my rebuttal testimony. It's hard to say for certain if by removing Carne, we would remove most of what's in there.
Well, let's look at it differently. If you add 130 megawatts of Carne, isn't that going to be a driver of more curtailments?
It's possible, but like I mentioned, there's a lot of things that go into curtailing, a lot of factors, and it's really hard for us to say for sure.
Is El Paso Electric anticipating adding solar or other forms of renewable energy as jurisdictionally dedicated resources in Texas?
Yes, ever since after our IRP in 2021, and after based off of these last two RFPs, El Paso Electric intention is to go and do jurisdictional RFPs to acquire the needs of each jurisdiction.
And do those include, for Texas, which doesn't have the New Mexico RPS requirements, do those include, are you anticipating or planning on adding renewables? Texas.
In Texas, it's potential. It will have to be based off the bids received from the RFP. Texas does not have an RPS requirement per se, like New Mexico does. So if the lowest cost resource end up being renewable, we would definitely add that for Texas.
And are you familiar with Mr. Oliver's testimony in this case?
I am.
I guess you're familiar. Actually, you're familiar with the. Did you work on the Texas? Okay, slow down on the acronyms. The Texas RFP that was going on somewhat simultaneously with this one.
Yes, I was involved.
And are you familiar with the issue? With Mr. Oliver's? Are you familiar with Mr. Oliver's testimony that in the best and final offer round for New Mexico, the company did not consider the EDF Milagro project because it had been selected for Texas in the Texas RFP?
I am familiar, but the reason why EDF was not selected for New Mexico was because it was not chosen as a lowest cost resource. DESRI was.
Well, I guess I'll ask them. So anyway, let's just, is EPE pursuing a significant amount of renewables through that Milagro project for Texas?
Madam Hearing Examiner, I'm going to object to this line of questioning. EPE, I believe, is in ongoing negotiations addressing the winning bids from that resource. And so I don't think that Mr. Martinez is at liberty to discuss specifics of those ongoing negotiations.
Ms. Stevens, your response?
I understand. I understand and respect the point being made. However, when we get to Mr. Oliver's testimony, and I think Mr. Martinez may be able to testify to this as well, we were told that the company, Mr. Oliver's position, it's in a footnote in his report, was that or maybe it's in the text of his report, is that EPE declined to even consider the EDF Milagro bid in New Mexico because of the fact that it had already been selected. So that's become public already, is about as public as can be. So I'm
Madam
not
Chair,
Well, I
what
would
the
say,
objection is.
Ms. Olson.
I would just say if Ms. Stevens is asking Mr. Martinez about a specific piece of Mr. Oliver's testimony, she can either point Mr. Martinez to that testimony or ask Mr. Oliver those questions, but I object to her paraphrasing her interpretation of Mr. Oliver's testimony and then asking Mr. Martinez to confirm it.
Well, I'm going to actually sustain the objection as being beyond the scope of Mr. Martinez's direct testimony, unless you can identify in his direct testimony or his rebuttal testimony or supplemental testimony where he discusses the Texas RFP. Because, you know, I would also suggest that questions respect to Mr. Oliver's testimony should go to Mr. Oliver.
Let me approach this from a different angle then. The modeling that you did, Mr. Martinez, to develop the round trip energy losses here on this exhibit VMS, did that take into consideration Texas as well as New Mexico resources and loads?
This updated table VM2S, and it did not. It removed any Texas portion from it.
How did it remove? Did it model the whole system and then remove Texas, or did it model two separate systems?
In our analysis, our analysis included the entire system when we did our curtailment analysis. And once we were able to determine the number of entire system, we removed Texas portion by looking at the jurisdiction allocation, which is approximately 80%.
And this takes us somewhere else in your testimony, which is the testimony about the allocation methodology. Let me find in my notes because it's not where I was ready. Give me a second here. Okay. This is, I think this is, I'm sorry. I literally have been shuffling pages as the stuff came in this morning. I believe it's your rebuttal testimony. It's got to be in your rebuttal testimony.
Would it be 1034?
I'm right. Actually, I'm right. Give me 1 second. I thought I was right in it, but I'm not. Yeah, I guess I was right in it. Pages 10 to 11 of your rebuttal testimony. Even earlier than that. You talk about the allocations. Yeah. Okay. So you talk about, and maybe I misunderstood this, but I read this as EPE expects to allocate all curtailments based on jurisdictional allocation. And there's a weird comma in there on line 4, and then again on line 6.
What page? I'm sorry, what page are you on?
It's page 10 of 34 of the rebuttal, exhibit EP exhibit 4. And this is when you discuss how you'll allocate curtailments. And then I don't know what, first of all, this means that EP's system, solar resources will be the first curtailed. is that comma meaningful? I interpreted it to mean that that the Buena Vista 1 and Macho Springs would be the first because they're system resources. Is that what you meant to say?
Yes, ma'am. That's what I meant to say.
And then once those are curtailed, then you will begin now to line 6 to 7. EPE and begin curtailing jurisdictionally allocated solar project proportionally based on jurisdictional allocation as well. Is that what, when you just said use 80%, is that what you were referring to, or were you referring to the Macho and Buena Vista 1?
Well, when I said 80% earlier, that had to do with our curtailment analysis that we did. And this one here on page 34 of my rebuttal testimony is more talking about on an operational sense that once it comes down to start curtailing solar resource, if we need to, we think it'd be best for us to start with the resources that are our system resources to be able to share the cost of any curtailment. And once those are done, then start looking at individual solar projects that are allocated directly to jurisdiction and allocate them proportionally, based off of approximately 80 to 20%. I believe on my last 10 and 11, I say, just to give an example, I say EP will curtail 2 megawatts for New Mexico allocated.
I'm sorry, please slow down. Please.
Oh, I apologize.
That's okay.
EP will curtail 2 megawatts from New Mexico allocated solar resource for every 10 megawatts of solar curtailment.
So this did leave me confused. Now, we understand that at least presently, and certainly once if Kearney were added prospectively too, New Mexico has a disproportionate amount of jurisdictional renewables compared to Texas. Is that right?
I think that's, yeah, I would say so.
Yeah. So this, with the 80-20% in lines 10 through 11, would you curtail? How would that? Well, let's just say that you've got. This is hypothetical. Just let's just say you've got. Totally hypothetically, 200 New Mexico dedicated, 100 Texas dedicated. Would you be? How would this 80-20% apply? Or would it apply?
So hypothetically speaking, I guess what we mentioned, if once we reduce all the solar resources, we'd start going to the resources that are directly allocated based off jurisdiction, we would start reducing those first. I'm sorry, we would start reducing those second proportionally, like I mentioned, 80-20.
Well, and I would you lump them together and then do 80-20, or would you turn them into 2 pots, the New Mexico pot and the Texas pot? If you don't know, you don't know.
Yeah, I'm trying to think of it visually. I guess we would try to do is whatever we think would be best, for both our New Mexico customers and Texas, while maintaining the integrity and security of the system.
Now, with the dedicated resources, there's no that are being collected through the RPS cost rider. There's no question, is there in your mind, that all of the costs, including curtailment costs, would go directly into the RPS cost rider?
I believe that might be a question that be better answered by Mr. Rene Gonzalez.
I don't think Mr. Gonzalez talks about that sort of thing. I'm not sure he knows what the plans are.
Yeah, I'm not sure exactly how the cost that goes specifically to the RPS rider would be calculated. I think he'd be a better witness to answer that question.
But I do think that you are the witness to answer this question. the Carney contract has a provision for adding a PTC adder for curtailed energy, is that right?
Yes, that is correct.
And that's not in the Buena Vista, that something like that isn't in Buena Vista, well, is it in any of your other renewable energy contracts that we've seen?
No, it's not. Currently, it's the only one that has it.
And and this is thinking as a system planner, not necessarily as, I'm not asking you to do the rate allocations here, but as a system planner, would you take that into consideration when you're deciding operationally who you curtail, because you're going to have to pay a surcharge basically for Carney curtailment, but not for a say a Macho Springs curtailment?
Yeah, most definitely. We will definitely take that in consideration. So with that being said, I think it'd be safe to say that the Carney project would probably be the last one to be curtailed, because it does have an extra, like an incremental cost to customers that the other contracts don't have.
Now, do you think that the Public Utility Commission of Texas is going to be totally on board with that approach when you have to start dealing with not just the MMPRC's approach to rate cost allocations, but also the Texas consumer's standpoint?
I'm not sure exactly how the Texas would be affected by this, but again, we would curtail both other projects based off of jurisdiction allocation. So we would only curtail Texas based off of, again, their 80% allocation.
I'm sorry, based off
Of their 80% allocation.
But you don't know whether that's the 80% allocation of everything or of Texas dedicated.
It'd be, like I mentioned earlier, it would first be the systems, and then if there's any ones that are directly allocated to Texas, we would start reducing those in New Mexico proportionally.
Let's see. As for this surcharge, the PTC cost, does that will that affect how will that affect the pricing of other resources? For example, do you know that some of the oldest REA resources in New Mexico have average prices of over $100 a megawatt hour?
I believe there are some that are over that amount, correct?
So will you take that into consideration when you actually curtail, or would you just kind of take as a rule of thumb you don't want to pay the surcharge?
No, we would take everything in consideration. Yeah, I'm not sure if all of the PPAs actually have a mechanism to curtail, to be quite honest with you. But we will take everything in consideration and make sure we make the best decision that's right for our New Mexico customers.
But you can't tell us how that's going to be, so we can't confirm it.
I'm sorry, so we can what?
How can we confirm it if you can't tell us what it's going to be?
I believe I have been trying to explain how we will try to allocate them. Maybe can you repeat your question maybe again one more time, please?
Well, let me just start and finish with another hopefully simpler question. And that is, if a curtailment occurs, no matter how you choose, well, first of all, two-step question. First of all, will the actual curtailments on the ground physically, will they be a function of economics or of economics meaning or of physical circumstances, location, output?
Yeah, most of the curtailments, I would say that come for a reliability need. I believe. Now, there could potentially exist a condition where it might be beneficial for New Mexico customers to be able to back down some of our solar generation to, potentially maybe get some power that, in essence, where we get free power and people are paying us for that, some negative price power. We would definitely look in consideration, but ultimate goal is to make sure that we meet the REA requirements. So we need to be very cognitive of that if we ever do any type of curtailment due to for economics.
And I apologize for bouncing around, but you raised that negative price power option, and that's on page 11 of 34 of your rebuttal testimony. I'd like you to also look at your I guess it's city exhibit, it's commission exhibit 2, commission exhibit 2, where it's page 7, it's page 9 of 11 with the footers, and it's page 7 of it's the last page of the actual testimony.
Okay. We look at commission exhibit you mentioned.
Commission exhibit, yeah, it's the one that was filed today. Commission exhibit 2, which just doesn't have a number on it yet because it's got the. Are you with me?
I am. I cannot find
last page of your supplemental.
Oh, last page of my.
Last page of the supplemental. You had it open to the VM, the table. Now we're going to the last page. Words.
Okay. Okay, I'm there.
Okay, so I'm looking at the first question and answer, full question and answer on that page. Could EPE secure market renewable energy to make up any deficiencies? And you say not likely. EPE has attempted multiple times in previous RFPs to require market renewable energy on a short-term basis, but has not received any bids. I guess my question is your testimony in your rebuttal about the prospects of negative priced energy consistent with the statement that you don't expect to be able to purchase renewable energy on the market?
Yes, they are consistent. One of them is talking about hourly pricing, where there are opportunities for EP to possibly acquire some renewable power potentially, or on an hourly basis. This statement was mainly when we're talking about short term is for a few months or to possibly a year, something we can put in our planning, in our LNR for planning purposes.
In your LNR or in your RE? Oh God, we got so many acronyms here. Or in your Renewable Energy Act program plan.
And yes, in our Renewable Energy Act plan.
Okay. So you were asked in the both you and Mr. Novella were asked, I think, in the bench request whether there are alternatives, if alternatives, at least short-term alternatives, to make up the difference if Kearney weren't approved. Is it true that there are, maybe not secured in advance, but there are opportunities out there to get renewable energy at low or even negative prices at times when there's like a surplus of wind or a surplus of solar floating around in the region?
None that we can depend on planning purposes.
Okay, now let's talk about what you really need for planning purposes then. Let's go back to your VM, you're looking at 2S, right? Is the one we decided was the right one?
Actually, the correct one should be 1S. It'd be
1S, okay. So I think I'm okay. Well,
I want to point out, Ms. Stevens, that we're getting very close to the end of your time.
okay. I think I'm getting there in a very roundabout way. Yeah, one. Okay. Well, which one do you want to use? 1S or 2S? I was looking at the I was going to look at the 2S because of that 37% factor that you've calculated there that we talked about earlier on column 2025 column. I think this is probably the right one to look at right now.
Okay,
Okay.
sure.
So you agreed earlier that the 10,400 round trip energy losses should be added back into the 649 figure, right? To get where your actual position will be, you do question whether the 9,000 should continue to come out. So, so that ups that a little bit, but if assuming that you're at 37 to 38%, how much energy, it's meaning that you're about 2 megawatts, 2 to 3% short. How many, let's call it 2. How many looking at, again, your total RPS requirements, your total forecasted requirements, how many megawatt hours of energy would you need in 2025 to hit the 40%?
Based off of this table, I guess adding the 10,000, we probably need about 40,000 maybe.
Yeah, I came up with a little smaller number, but I probably took it. Okay, so 40,000, and you're aiming to get 398,000 with 265 in the first year. 40,000, how many, if you wanted to buy 40,000 megawatt hours based on your own assumptions, and maybe these are, I know the number came out of Mr. Oliver's report, but I think you're probably familiar with the planning assumption that you made for these projects was a 35% capacity factor. Is that right?
I'm sorry, you're referring to the solar, to the Carney
project? The solar bids, yeah, in this case.
So yeah, the solar bids have what we call an effective load carrying capability, or ELCC, of 43% for all solar projects coming in 20.
That's not what I'm asking. That's the.
Oh, I apologize.
The capacity component. I'm asking for the energy. Did you use this? I may have to ask this to Mr. Oliver. I just was wondering very roughly how much capacity you would, how big of a purchase you would need. And again, if you had a calculator, but if you don't.
Yeah, I don't have those numbers in front of me.
And would you agree that the 40% that 40,000 that you eyeballed is less than a quarter of the 175,000 megawatt hours that the company identified, quote unquote, in its RFP is what it needs to meet the REA of 40%, RPS of 40% in 2025?
Yeah, just I do want to point out that the 175,000 would also help us cover any deficiencies from previous years as well.
Yeah, I understand that. I think we've already raised the possibility of that being extended over a period of time. This is a couple of quick technical questions for you. How much of New Mexico's total energy would Carney represent?
Based off of calculations, I'm thinking approximately about 22%, I believe.
And how much of New Mexico's peak day, do you know how much of New Mexico's peak day capacity or demand would Carney represent?
I don't actually have those figures in front of me. I would have to do some calculations to get that for you.
Is that because you don't know the New Mexico load, or because you don't know what the capacity of Carney is?
Just because, yeah, at this moment, I would not know what the New Mexico demand would be at the time.
Okay. And if we had the demand, we could just divide it? Divide the capacity by the total demand, get a percentage? That's simple enough?
Potentially, yes.
Can you tell me why the number that's being used in your testimony elsewhere in this case is that Kearney will provide approximately 121 megawatt hours? Pardon, about 121 megawatts for purposes of load when it's 130 plus 130 energy plus 65 battery.
Yeah, the 121 was referring to the amount of capacity that we could use towards meet our capacity needs for New Mexico customers. And that's the way it's calculated is looking at the ELCC that I mentioned earlier. For solar, the ELCC for solar is about 42%. So if you multiply 42% times 130, I don't recall right now the exact number that is. For battery, it's 65 megawatts of battery. It has 100% ELCC. So if you add the 65 plus the 42% of 130, you'll get to approximately 121.
I'll take you back very quickly, or maybe not even just out of memory if we can do it because my time is short. On the IRP, the 2021 IRP, are the loads and resources tables in there based on good old fashioned peak day, real, 1 hour of the year, or are they based on ELCC?
The LNR tables that are provided in the RP was the first one that I brought up are based off our old methodology, where we're using approximately 75% of contribution to peak for some of the older projects and approximately 25% contribution to peak for other newer resources.
Okay, so there's a little bit of apples and oranges issue here?
I believe so, yes. We changed our methodology in 2021.
Few quick questions here.
I think you have about a minute left.
Okay, yeah, I understand. Oh yeah, in your testimony, in your rebuttal testimony, when you make the adjustment and explain that Buena Vista 1 already has round trip energy losses built into the numbers. Look at seals, and that doesn't seem that's not the way that I've understood the contract, but would you look at CLC exhibit 11, please?
Yes.
And if you look at page 17, section 1.4.76, it's on page 7.
I'm sorry, see, what page was this again?
On page 17 in the footer.
Okay.
The Bates number.
Oh, the Bates number. Oh.
Yeah. Is it down the Bates number, please?
Here on page 17 of Bates.
Yeah, yes, page 17 on the Bates numbering. 1.4, section 1.4.76 is described as delivered as measured at the PV meter. And I'm not going to, since the time is short, I'm not going to take you through the whole contract, but is it your understanding that contrary to the terms of this contract about a PV meter, including a diagram that shows a PV meter being at the PV facility before power either goes directly into the company's system or goes into the storage facility, is it your understanding that storage losses really are not covered through this contract?
Yeah, it is my understanding that El Paso Electric would only have to purchase energy that's delivered at the point of interconnection, which would include all energy coming either from the solar facility or from the battery. So,
and what is your basis? What is the basis? Is there a basis for that other than the contract themselves?
Yeah, so I believe this was what I was mainly referring to is why we removed the round trip efficiencies. So I think that was a big reason why. And based on my understanding is that reason that why round trip efficiencies were removed was because, again, EP would only have to purchase what's based off of the point of at the point of interconnection.
And that's based, that understanding is based on your reading of this contract?
It is my understanding of the contract. Yes, it is.
Okay. City moves to admit CLC Exhibit 11, the Buena Vista 1 PPA.
Madam Hearing Examiner, I don't generally object to the Buena Vista 1 PPA coming in, but that agreement is subject to amendments that are currently pending before the commission in another docket. And so the PPA as it stands isn't accurate because it's been amended.
I'd be happy to, I have my next exhibit number 13, the amendment, and I'd be happy to ask to admit both of them, Mr. Martinez, if I have to ask Mr. Martinez if he's.
Well, you
familiar.
know, right now we're beyond time for your cross-examination.
So may I admit
Stevens.
13 and
So,
12 and 13?
I will
Satisfy Ms.
take
Olson's concern?
those up in the morning. Right now, I think we want to try to get through Ms. Soul's testimony before we finish for the day. So we'll discuss those tomorrow because Mr. Martinez will be back. But in the meantime, I am looking at changing our start time for tomorrow to 9 a.m. If Ms. Gonzalez is available, I can have notification provided on the website that the hearing is being rescheduled to start at 9 tomorrow.
I can.
Thank you. And
Is there any
Mhm.
objection from any party with respect to starting tomorrow at 9 a.m.?
And I'd
Mr. Martinez.
No objection on my side.
I'd like to thank Mr. Martinez very much and look forward to seeing you again fairly soon in the next case.
Likewise. Thank you.
Thank you, sir.
Okay. All right. Well, we'll take up exhibits, what's been marked as exhibits 11 and 12, the Buena Vista agreements tomorrow. But at this point, I would like to turn to Ms. Souls for her cross-examination of Mr. Martinez, and hopefully we can complete that today.
I will do my best. Thank you. Good afternoon, Mr. Martinez. I'm Mary Lee Souls. I'm a pro se party in this case.
Pleasure to meet you, Ms. Soul.
Would you please go to your rebuttal testimony, page 7 of 34, beginning at line 2. Are you there?
Yes, ma'am.
You agree that 10 megawatts of community solar will not be available for the entire year of 2023. But you disagree that no community solar generation will be available in 2023. Is that your testimony?
Yes, it is.
Are you aware of a specific community solar project that you expect to be operational before the end of 2023?
I mean, based on my understanding of the community solar going on right now is I believe they're expected to have the RFP, they expect to pretty much, I believe, wrap them up by April, I believe, which means I think there's a good possibility that we could have something either by November or December. It's just based off of kind of assumption that I have.
You're not familiar then with anything in particular that would be seeking to connect with El Paso Electric's transmission and distribution system?
No, I don't know they have specific details on that.
And if they could actually bring that about between April and November, maybe we could learn from them how they do that. Please go to line 13 of the same page. And here you indicate that Buena Vista 2 could be providing renewable energy as soon as the end of January 2023. Is that correct?
At the time that the rebuttal testimony was written, yes, that was a potential that could happen.
And has Buena Vista, is it in operation today as we speak?
It's going through testing. We are seeing energy coming through, being delivered to New Mexico customers, but I do not believe it's reached an actual COD yet.
Is that because El Paso Electric chooses not to accept energy ahead of the proposed June 1st commercial operation date?
No, it is my understanding that we're willing to take it as soon as the project is available.
Do you have any insight into what's holding it up? Why this testing hasn't been completed at this point?
I do
rather
not.
than months ago.
Yeah, I do not. I think that might be a better question for Mr. David Hawkins to answer.
Very well. And you indicate that you assumed a conservative commencement of operations date for Buena Vista 2 of April 1st, for which you calculated an additional 10,400 RECs. Is that correct?
I believe so. Yes, that is correct.
And would you please explain the calculation you did to arrive at 10,400 additional RECs?
Yeah, it was pretty much a simple calculation. Is I took the expected annual output for the year, kind of, divided by, by 12, and then included those extra months, prior to the COD of June. So I had an extra 2 months.
So basically you're assuming what, 5,200 RECs per month?
I believe so.
Okay. Would you please go to page 8 of 34 at line 5?
I'm right there.
All right. Here you indicate that NextEra expects to have Buena Vista 1 in service by mid-March. Is that correct?
That was our estimation at the time the rebuttal testimony was written. Yes.
Has that estimation changed?
Again, I don't have quite insights. Last I heard is that they would begin testing in mid-March.
So that's not the same as meeting a COD, correct?
That is correct.
And will El Paso Electric accept energy from Buena Vista 1 ahead of the proposed June 1st, 2023 commercial operation date?
Yes, in efforts to assure that we meet our requirement for 2023, I believe that is our position, to try to take it as early as possible.
Is it fair to say that energy and RECs from Buena Vista 1 and 2 ahead of the proposed commercial operation date of June 1st, 2023 are required if El Paso Electric is going to meet its 20% RPS target in 2023?
I'm sorry, if El Paso Electric is going to meet its
20% RPS target in 2023.
Assuming we remove all the RECs from DG, like I did in my rebuttal testimony, we would need for at least BV2 to be in line by April in order to meet our RPS for 2023.
Please go back. What do you mean assuming DG RECs? What does DG RECs have to do with this?
I apologize, Ms. Souls. I got confused. I meant to say the community solar. Assuming we remove the community solar, the full 10 megawatts for 2023 are removed, then yes, we would need that.
And then is it fair to say that whether or not EPE meets its 2023 RPS requirement of 20%, that's entirely at the discretion of El Paso Electric and how quickly and efficiently it can complete the testing?
I would not characterize it as it being only on El Paso Electric. A lot has to do with the work that NextEra still needs to do in order to complete the project.
What work is that?
Again, I think that question would probably be better asked to Mr. David Hawkins. He should have more information on that.
Very well. We will come back to your rebuttal testimony. Please keep it available.
Yes,
but now let's go to your direct testimony. Page 427 of 821.
Okay, I'm there.
I'm not. I was still where Ms. Stevens left you. At line 4, you claim that the Carne project is consistent with El Paso Electric's 2021 IRP, and that El Paso Electric utilized the same process to select resources. Is that correct?
That is correct.
And did El Paso Electric use the same inputs other than what you specify here?
Not all of the inputs, because the tech, but most of the inputs will be the same from our 2021 RFP and our 2021 New Mexico RFP.
Did you use the same inputs in your DG forecasts?
We use the same DG forecast on both the IRP and our Texas RFP.
I'm asking about the IRP and the New Mexico RFP.
Yeah, the DG forecast that we use, it was used for both the 2021 IRP as well as the 2021 New Mexico RFP.
Thank you. And did you use the same forecasts for generation unit retirements?
Yes, we did.
And do you recall that there are supposed to be 2 units that retired at the end of December 2022 in those forecasts?
Yes.
And has El Paso Electric filed for abandonment of those resources?
As far as I know, we have that.
Very well. I was going to take you to your exhibit VM3, but am I correct that that has been replaced first by the table in your rebuttal testimony and now by the tables in your supplemental testimony?
Actually, the numbers from my rebuttal and my supplemental are actually the same. It's just the format's a little bit different. So I would go with the supplemental being our latest and greatest.
Then is it reasonable that we don't have to look at your exhibit VM3 in your direct testimony, but we can look at your table VM-1S in your supplemental testimony? I'm sorry?
Please repeat the second VM you said. But we can look at your table VM. You turned your head and I did not hear it. I'm sorry.
I'm so sorry. I'm trying to look at lots of documents.
I
Table VM-1S in your supplemental testimony.
Yes, I would say that's our latest and greatest.
Very well. Then let's go there. And I have that as being on.
Okay, I can't hear you again.
Yeah,
On
Ms.
page-
Souls.
I'm sorry, I'll try. On page 4 of 11 of your supplemental testimony.
Yes.
First, I want to express my appreciation. Am I correct? You removed distributed generation, made a separate line item for that?
I did. A lot was attributed to your testimony, and I figured it'd be easier for everybody if I was to separate it.
Thank you very much. So this represents what used to be combined. Distributed generation used to be part of RPS energy approved resources. Is that correct?
Yes, ma'am, that is correct.
Did you change the numbers at all, or do you just represent them differently?
The numbers remain the same. I'm just representing them differently.
Excellent. In that case, I would like you to go to hold on. The supplemental testimony took me in different places. I'd like to go to El Paso Electric's 2021 IRP. You should have an exhibit, Souls Exhibit 5.
Yes, I do.
And you recognize this as El Paso Electric's most recent commission accepted integrated resource plan?
Yes, I do.
would you please go to page 25 of 390?
Almost there. I'm there.
Very well. And do you see table 6 here under recommended portfolio?
Yes, I do.
The incremental resources portfolio additions for New Mexico. Would you agree this is what the commission accepted as the IRP?
Yes.
And do you see a new solar resource to be added in 2025?
This particular one, I do not.
Please go to page 151 of 390.
Okay.
I'm sorry, what was that page number again, Ms. Souls?
Well, I thought it was page 151 of 390. Yes, page 151 of 390.
Yes, I'm here.
And do you recognize this as one of the many reports from the modeling results?
Yes, I recognize. It's been a while since I've seen it, but yes, I do recognize it.
All right. And would you agree with me that the section in the middle that's in gray is what was the recommended portfolio modeling result? This is the one that they call the least cost case plus the ETA resources.
I'm sorry, please repeat the least.
Least cost case plus ETA resources.
Yes, I believe so.
And you understand ETA to refer to the Energy Transition Act?
That is my understanding.
Would you agree with me that Energy Transition Act resources would be the same as Renewable Energy Act or REA resources for the purpose of our discussion?
It is my understanding as well.
Do you see the values represented here are in gigawatt hours?
Yes, I do see that.
And how do gigawatt hours relate to RECs?
1 gigawatt would be approximately about 1,000 RECs, I believe.
Thank you. Do you see the lines? There's 3 of them actually, but in the gray part, do you see the line BTM solar?
Yes, I do.
What is that?
I believe that's behind the meter solar.
Is that essentially equivalent to DG?
Yes, it is.
All right. What value do you see for 2021 in that resource portfolio?
In that resource, what? I'm sorry.
Portfolio?
This one, yeah, it's 37.
That would be equivalent to 37,000 RECs in 2021?
Yes.
And what do you see for 2025?
2025, I see 165.
And that would be equivalent to 165,000 DG RECs in 2025?
I believe that is my understanding, yes.
At this point, could we go back to your table VM1S?
Yes, of course.
You so conveniently, I do appreciate it, separated out the DG line.
Yes.
And what is it that you're forecasting here for DG RECs?
I'm forecasting approximately about 101,533.
And would you agree that that's approximately 63,500 RECs less than what was used in the integrated resource planning process?
I believe so. I do want to point out that This table in VM1S takes the most current DG forecast that was provided in 2022, whereas the RP was based off the project, the projected forecast that was calculated in 2021.
So if the IRP forecast that you said this was consistent with was used for this, what would that do in terms of the RPS standard in 2025?
Well, again, what we used when we submitted our application was we're using the most up-to-date information we have at that particular time. And right now, the 101,000 does reflect that. And I apologize, I think I missed the second part. Can you repeat your question again, please?
So I understand that's how you came up with this. I'm asking you to use the additional 63,500 DG Recs and tell me what that would result in if that was true.
Well, I think right now we're kind of speaking in like hypotheticals, but
it's all a forecast. Everything here is a forecast. I get that. So what would it mean if that were the forecast?
Well, obviously that would increase our recs available we could use towards meeting our RPS.
Would it satisfy the 40% RPS if it were accurate?
I'm not sure. I would have to do the calculation.
I'm going to ask you to do that.
Madam Hearing Examiner,
An additional 63,000.
Madam Hearing Examiner, I'm going to object to asking to do calculations on the stand. If Ms. Souls wants to give him numbers to plug into a calculator, he can read that number that comes out of the calculator. But aside from that,
then let me suggest that you go to table VM2S.
Mm-hmm.
Table VM2S, you've removed the impact of Carney. I believe you agreed with Ms. Stevens that you should add back that 10,400 that is on the line of round trip efficiency loss.
Yes.
So now to this number 649,000, maybe you'd be willing to round that to 650,000 just for rough calculations.
Sure.
And if you add 63,500 and 10,000, would you agree with me that that exceeds the 701,000 that is required in these forecasts to meet the 40%?
Based off of this forecast, which does include the current rule on 572, it looks like it might, but if you look at further down tables, it includes what happens once the amended 572 comes into place, and we can no longer count on the 101,000 or the additional 65,000 that you had mentioned.
Yes, sir. I understand that, but we're not there yet. I will go there. I'm asking you to deal with this table VM-2S and to make those adjustments.
So again, hypothetically speaking, if we look at table VMS2, the deficiency margins show about 51,000 margin. If we take away the round trip efficiency plus add the 65,000 hypothetically, it could potentially get us over the 40% of the current rule.
Off the what? I'm sorry.
Off the current rule.
And would you agree with me that when that current rule goes into effect, everything's off the table? That now we have a problem in 2023. Would you agree with that?
If it is, if it applies in 2023, we would have a problem, but it is my understanding that it would begin in 2024.
And if it applies in 2024, do you anticipate that's a problem to wipe out all of the DG recs?
No, at that moment, once the Buena Vista and the Hecate projects are up and running, we should be able to meet our RPS target of 20% in 2024. And I believe one of my tables shows that as well.
And in 2025, that could create a problem there as well.
Again, based off of that projection, assuming the Carnet project gets approved, we should be able to reach our 40% target in 2025,
But not without the Carney project.
but not without the, yes, at least based off of that projection, yes, correct.
And we are forecasting that it was possible to reach it with the DG Rex and without Carney.
I'm sorry, can you say that one more time? I apologize.
The DG Rex without Carney, that we would meet it.
Off of the current rule right now without Carney, but I'm sorry, I got a little bit lost. Are we still talking about the additional 65,000?
Yes, sir, we are.
Okay. So assuming we got an additional 65,000 recs of DG, and assuming Carney is not there, based off of the old rule that we can still count for all of DG, we may be able to meet the 40%.
Very well. Now, a minute ago, we also looked at the 2021 DG Rex in the IRP with an assumption that that would be 37,000 Rex. Do you recall that?
Let me go back real quick. I believe that's true. 37,000, yes.
And yet in 2021, the actual DG Rec production.
I'm sorry, I'm missing your question. And yet in
Oh.
2021,
The actual DG Rec production was 62,542. Is that correct?
That is correct, yes.
So in 2021, the DG Rec production significantly exceeded the IRP projections. Would you agree with that?
Yes.
Then, Mr. Martinez, why would you not think that the IRP projections for DG Rex are conservative?
Yeah, again, for the forecast of as far as how the DG Rex were calculated, Mr. George Novella might be a better witness to ask. I simply took his forecast and plugged it into our model to determine, what our needs are.
Oh, I'm sorry. He referred all of this to you.
Madam Hearing Examiner, I'm not sure that Mr. Novella referred forecasts for the DG Rex and the IRP to Mr. Martinez.
Madam Hearing Examiner, my recollection was every question I asked about the IRP sent me to Mr. Martinez. And he eventually said, if you want to ask about the IRP, you should speak to Mr. Martinez.
Well, Mr. Martinez should answer the questions to the best of his ability.
Okay. Yeah, so the only thing I can say is that the forecast that was done for the IRP in 2021 was based off of a projected forecast done in 2021. And the DG forecast that I'm using right now in table VM3S was based off our most current projection. And it shows different information than what's in the IRP because now we have better information or newer information, I should say.
Is it fair to characterize the IRP projections as conservative, given the actual history, most recent actual history we have for 2021?
Yeah, again, the IRP was based off the most current information at the time the IRP was conducted. And different circumstances now exist when we now submitted this case.
All right. I think I have some more questions. Again, I'm going back to the questions that I asked Mr. Novella, and to the best of my ability, what he referred to you. I asked him about global supply chain issues. He had testified that EPE has experienced global supply chain issues, and he referenced that in relation to Buena Vista and Hecate projects. What are the global supply chain issues that El Paso Electric has experienced related to the Buena Vista and Hecate project?
Yeah. On specifically to the Buena Vista and Hecate projects, I would defer to Mr. David Hawkins. He's a little bit more involved in those projects than I am.
Okay, give me a moment. I'm going to have to highlight with a different color. right. I asked him about the 2021 RFP and his statement that it was primarily to meet the 40% RPS by 2025. Would you agree with that?
If that's what Mr. Novella said, do I agree that the RPS, that the RFP was primarily for REA? Is that what you're asking?
To meet the 40% RPS by 2025.
Yeah, so our RFP was to meet our RA requirement in 2025, as well as meet capacity needs for our New Mexico customers.
Was one or the other of those needs primary?
I wouldn't think so. I think they both were equally as important.
Thank you. I asked him a number of questions about the proposed procurement as a dedicated resource.
Mhm.
How does El Paso Electric service only a specific customer with a dedicated resource?
I'm not sure I understand your questions. I may apologize.
Yeah, I'm afraid I didn't understand his testimony. Do you keep the electrons separate?
No, of course not. El Paso Electric does not track electrons.
If Carne were a dedicated resource, what subtracts the things that's already in rates and rate base to make up for it replacing them?
Yeah, I think that might be more of a regulatory accounting question.
Yeah, he referred it to you.
Well, yeah, as far as the actual mechanism, as far as how New Mexico customers are going to be billed based off of dedicated resource, I'm afraid that'd be more of a regulatory accounting question.
Does El Paso Electric envision that the cost for Carne would go into the RPS rate rider?
That is my understanding.
And even though I think you said equally it was for capacity as well as RPS, does that mean that half of it should go in the RPS rate rider?
Again, I would not know exactly the mechanism of how the cost is separated, either through a rate case, FEPCAC, or through a rider.
So are you imagining that the cost for Carne is simply added to the cost that New Mexico ratepayers already pay?
I wouldn't say it's added. The generation is going to displace other types of resources. So I wouldn't go as far as saying it'll be added. It will be displacing some other inefficient units potentially.
So it's replacing those inefficient units that you haven't yet filed for abandonment. Is that correct?
Potentially. I'm not sure exactly. We'll determine whether we need those units or not. Will have to depend on reliability needs. And for reliability needs, I think I defer to Mr. David Hawkins. He'd be a better witness to talk about, reasons why those units would need to be done for reliability.
All right, let's move on. I've got that from Mr. Hawkins now. So if Carne is not required for El Paso Electric to achieve the 40% renewable energy, would you still think that it belongs in a Renewable Energy Act filing?
Madam Hearing Examiner, I'm going to object to this question. This is the same question Ms. Stevens asked. This is not EPE's position, and it's asking for a hypothetical.
Madam Hearing Examiner, this was the same question and the same objection as when I asked Mr. Novella, and you did not sustain the objection, and you allowed me to ask him, and he referred me to Mr. Martinez.
Well, but I think that we rephrased it so that to ask whether EPE had a plan or had made that determination. And if they have, then yes, Mr. Martinez can discuss that.
So, Mr. Martinez, do you have the results of the DG recs that were generated in 2022 yet?
Based off my table VM3S that we're looking at, did you say 2023 for DG recs?
I said, do you have actual results for 2022 yet?
No, we do not.
So we're not in a position right now to determine whether
missing your
or
question.
not,
I'm sorry. So we're not in a position right now.
to determine whether or not your forecast is conservative or the actuals are exceeding your projections as the IRP forecast would suggest. We can't determine that yet. We don't have new information. Is that correct?
Yeah, we have not compiled the energy to determine that at this point.
And so if the DG was significantly exceeding your forecast in table VM-2S, would you reconsider your position about whether or not that 165,000 DG recs in 2025 was reasonable?
No, again, I would go based off of the most current information provided to us by our research and economics group. That's what I would go off of.
Would your research and economics group have been the one to provide the forecast for the IRP modeling?
I believe it was a combination from them and as well as from E3, which is our consultant that we hired for the RP. E3 is energy and environmental economics. They're a consultant that we hired.
Why would they have been providing a forecast for DG?
Again, they were helping us throughout the whole transition. So I believe it was a combination between the two departments, collaborative department to determine the forecast for our IRP.
Mr. Martinez, do you see the inconsistency here that I'm struggling with?
Not necessarily, no.
165,000 recs versus 101,000 in 2025.
Yeah, and again, just right now we have a different forecast. I'm sure we had different numbers by then, so I believe forecasts could change from year to year. So on my side, all I have to do is just go based off of the most current forecast that's provided to me, and that's what I go off of.
Let me make sure. I may be done. Give me a moment, please.
Of course.
Oh, let's go back to the IRP. Mr. Novella deferred this to you. I'd ask you to go to page 31 of 390.
Sure thing.
Sure, you're
Almost.
getting there sooner than I am.
Yeah, I am, and also had to switch the view as well to see the other. I'm there now.
I did ask you about that. That's okay. Okay. Ms. Stevens was asking you about the contract and the provisions for force majeure. You recall that?
Yes, I do.
I'm going to see if we can do this without actually going to the contract. It appeared that the force majeure provisions applied to the seller. Is that correct?
I believe so.
Do you recall any force majeure provisions that apply to El Paso Electric?
Not that I can recall at this time.
Are there any provisions in the contract which would obligate El Paso Electric to make the whole?
And again, they're pretty long contracts. I haven't read them in a while, but based on my understanding, I don't believe there are any that EPE would have to pay.
And if you were in a circumstance where delay damages or the various other provisions, sanctions, if you would, protections were in place, would those amounts be collected from DESRI? Would they be directed to the El Paso Electric New Mexico customers?
I would believe so, but I may not be the best person to answer that. I think that might be more of a regulatory accounting question.
And in the negotiation of the contract with DESRI for the Carnegie projects, do you believe those contracts reflect adequate protections for ratepayers to assure that the May 1st date 2025 is achieved?
I believe so. I know I talked earlier that we had pretty significant daily delay damages if they're not able to meet the COD, and a lot of it was done to kind of make sure that we protect the New Mexico customers to make sure that we get the project running on time.
But didn't you agree with Ms. Stevens that if El Paso Electric as the transmission provider did not meet its obligations under the interconnection agreement, that there is a delay permitted of up to 180 days without those damages going into effect?
Yeah, there are some provisions in there that obviously I would excuse DESRI for certain force majeure events, like we had mentioned earlier. But I think for the most part, in case DESRI was able not to meet the COD due to other circumstances, we believe there's enough protection in there to, again, protect our customers to make sure that the project is there on time.
But what about if they weren't able to meet the date because El Paso Electric failed in its obligations?
Yeah, based off the contract right now, I believe it was 180 days, right? That they would not have to pay delay damages if it was due to interconnection as stated in the contract.
And so if El Paso Electric fails in its responsibilities for the interconnection, resulting in an interconnection delay, then 180 days takes it to the end of 2025. Is that correct?
Not sure. I think is it 6 months, I believe? So then I would put it in around November.
November 1st.
I believe so.
And 2 months of Carne operating, would that be enough to satisfy the RPS requirement?
I haven't done the projections. I'd have to do them, but I would say it'd be difficult, I think, to meet if it would get delayed that much, which is why I think it's important, right, to get it approved and make sure it doesn't get delayed anymore, because any delay could potentially keep us from not meeting our 40% RPS target.
And would you agree that 180 days of permitted delay because of an interconnection issue caused by El Paso Electric means that the expensive energy replacement over the summer months would not be protected for New Mexico ratepayers?
Again, based the way the contract is written, if there is delays due to interconnection problem, then DESRI would not be on the hook to pay for those delay damages based on what's stated in the contract.
And in establishing the timetable for the El Paso Electric Carne PPA and ESA with the date of May 1st, 2025, what is El Paso Electric assuming is the date that the interconnection has to be fully functional in order to meet that?
That's a good question. For that, I defer to Mr. David Hawkins. He'd have a lot more information on interconnection and milestones on that.
I believe that's all the questions I have for you right now. Thank you.
Well, thank you. You're welcome.
Thank you, Ms. Souls. Mr. Downs, do you have any questions?
I do not. Thank you, Madam Hearing Examiner.
Mr. Herman for Doña Ana County.
Yeah, I've got just one line of questioning. Good afternoon into evening, Mr. Martinez.
Good afternoon, Mr. Herman.
I was just reviewing your direct testimony, and I want to direct you to page 15, where you are discussing the all source RFP that EPE issued.
Mr. Herman, was that 1515?
Yes, Bates number 408.
Okay, thank you. Okay, I'm here.
So you are discussing an all source RFP. And then on page 17, in table VN1, you identify several proposals that were considered. Were any non-carbon emitting resources considered or provided in response to the RFP?
No, they were not. All of the bids, we received 86 bids, which are all listed here. None of them were from non-carbon resources.
That's interesting. And it was all for New Mexico, or was it for both Texas and New Mexico?
This one was specifically for New Mexico.
Well, that answers my question. Thank you.
Very welcome.
Utility Division staff, Mr. Borman or Ms. Regensburg.
I will defer to my co-counsel to see if she has any questions.
Good afternoon. No, I have no questions. Thank you.
So Mr. Martinez, I think that the gist of the questions from Ms. Souls and the city of Las Cruces related to whether or not El Paso Electric could meet its requirements under the REA without the Carne project. Did you understand that to be sort of the end purpose of many of the questions?
Yes, and based off of all the calculation that we've done, EPE cannot meet based off of our current plan, EPE cannot meet the 40% RPS target without the Carne project.
Okay. And what would happen with respect to sort of the backfill without the Carne project?
Wow. So if let's just say if the Carne project would not be approved, would pretty much take us back to the drawing board, and we'd have to reissue another RFP, go through the same process selecting. So which means that we're probably looking at most likely it wouldn't be until 2027 before we're able to acquire resource to meet our RPS target of 40%, which by then obviously would just make us deficient starting in 25, 26, and then it would keep us too from most likely being able to go retroactively and fill our deficiencies in years 20 through 22.
And how much could the Macho Springs project provide
So
if
the-
Carne was not approved and you had to use that as your alternative?
Yes, ma'am. Yeah, and I believe in some supplemental, we did provide that. But to answer your question, if Carne would not be there, and then we would use Macho Springs to make up the deficiency that Carne had left, based off of the current rule that we have right now, where we're able to retire. I apologize about that noise. I'm sorry. So based off the current rule that we're able to, in essence, use 100% of DG regs towards meeting RPS requirements, we would be fine with just Macho Springs. But it's as far as I recall, that rule may go in effect sometime this year. And once that happens, even with Macho Springs, we would not be able to meet our 40% target in 2025 without La Carne project.
Has Macho Springs been used to provide energy in New Mexico in the past?
Right now,
I understand that it. Sorry, go ahead.
I apologize, ma'am. Macho Springs is a system resource. So right now, approximately about 20% of Macho Springs being allocated to New Mexico, which is being used towards meeting our RPS requirements.
Okay. So currently, EPE is using some RECs from Macho Springs.
Yes, ma'am. Approximately about 20% of all the RECs generated by Macho Springs are being used to meet RPS requirements for New Mexico customers.
Now, since there's an addition of capacity, or would be an addition of capacity through the Carne project, would that replace any of the other existing sources that are in EP's portfolio?
Yeah, at this moment, based off of our latest LNR, there's currently still deficiencies for years 23 and 24, which means that the Carne project will help kind of meet those deficiencies. So once in 25, we will have a surplus in 25, but as demand starts growing and certain units starts getting retired, we will again have a deficiency for New Mexico. So to answer your question, we wouldn't necessarily remove any of the resources specifically because La Carne was done. In our plan right now, we are retiring Rio 6, I apologize, Rio 7 and Newman 1 after 2022. We did extend 20 Newman 2 from 22 to 27. So we did a 5-year extension. And this again, consistent to our RRP. In our RRP, we also elected to extend the retirement of Newman 3 and also Newman 4 from 2027 to 2031. So I just wanted to kind of give you a full scope of everything.
Okay. Now, given that EPE has been in a deficit over the last few years, has EPE received any form of incentive payment? Do you know?
I would not know.
What would EPE contemplate doing with the excess capacity from the Carne project?
Right now, it would just simply be used for to help us with our planning reserve margins. So just to kind of help keep the reliability of the system.
So you wouldn't sell it?
Our plan is not to sell it. Our plan is to use it for our New Mexico customers. And again, it just serves for reliability in case there's any type of contingency going on in the future that we might not be aware of. That extra capacity could help us, keep the system up and running and keep it as reliable as possible.
Okay. I do not have any further questions at this time. Ms. Olson, it is 5 o'clock. Would you like to? I think we could maybe go another 15 minutes if no one has an objection. Would you be able to do your redirect in that time, or would you prefer to start in the morning? And I should say that we will be starting at 9 tomorrow morning.
Madam Hearing Examiner, in an effort to move things along, I don't have any redirect. And I'm sure Mr. Martinez is anxious to get off the stand after the last 2.5 hours, 3 hours.
Okay. Well, I don't think then that we would have any recross.
I have.
Yes, Ms. Soul.
Yes, ma'am.
Cross would be
Based on your
inappropriate
question-
without redirect.
Redirect. I'm sorry, Mr. Borman, is that an objection?
Yeah,
That's
I
what I
would
was.
object. I mean, there's no recross without redirect.
Well, then what is the term when I have questions based on the questions asked by the hearing examiner?
Something you'll have to live with.
Well, generally, I believe, Ms. Souls, that my questions would also be in the category of cross-examination. And so generally, it would be up to the party presenting the witness to ask questions based on any and all of the cross-examination, but I don't believe that there's generally been a process for counsel who've engaged in cross to ask additional questions that would be in the nature of redirect based. But why don't you tell us what your question is, and then we'll see whether or not we're going to proceed for a short time, very short.
Yes, ma'am. So you asked questions about whether or not Carne would replace other existing resources. I wanted to follow up on that. And you asked questions about EPE being in deficit the last few years, and I wanted to ask additional questions regarding this response to that.
Madam Hearing Examiner, I would object to both those lines of the questioning. Ms. Souls already had opportunity to examine the witness on both of those topics, and I don't think you elicited new testimony on either of those.
I think we're going to start tomorrow with, who's the next witness, Ms. Olson?
Madam Hearing Examiner, I have one follow-up question or request. Mr. Martinez referred in response to you about a current or new loads and resources table, which I do not believe there is any loads and resources table in the record in this case. I don't even know which one he's referring to, but I don't believe that it's in the record. Whichever one it is, I don't believe that it's in the record. And that's the only follow-up question I wanted to ask.
Ms. Olson?
Well, I'm not sure. Is Ms. Stevens just asking, is the loads and resources table in the record?
Yeah, well, if it isn't, I guess I'd like to ask Mr. Martinez where it is, if he's relying on it. Yeah, the first step is whether it's in the record. Yeah.
Mr. Martinez, go ahead.
As far as I know, it is not in the record.
Okay. So I think at this point, we will see how many of these questions can be addressed with the remaining EPE witnesses. And if there is anything compelling, we can discuss whether or not there would be any basis for recalling Mr. Martinez. But I think we've had a fairly long day with a lot of information. And we are going to start tomorrow morning at 9.
Madam Hearing Examiner?
Yes, Ms. Stevens.
Martinez, whether he's referring to a 2021 or 2022 loads and resources table. I may be able to find it in some other filing to ask another witness about it, but if I don't even know which one it is, it's kind of pointless.
You know, Mr. Martinez offhand?
Believe it'd be either the 2021 or the 2022 LNR that's developed by the company every year.
And can you narrow it down to which one of those? Your answer to the hearing examiner.
We can go with 2021. That way it's at least consistent with the IRP.
Okay, thank you.
You're welcome.
Okay. All right, so who's the next witness tomorrow morning, Miss Olson?
I believe our next witness is Mr. Wayne Oliver, and he's been informed that we're starting at 9 and he's ready to go at 9 a.m. tomorrow morning.
Okay. All right, thank you everyone for your hard work today. It's appreciated, and we will see you all tomorrow morning at 9.
Thank you.
Thank you.
Have a good evening.
Thank you very much.